Please verify it and take it up 2 o'clock today.
Because I have filed the IE today itself, my lord.
So that your problem. I would have seen. Let it be tomorrow.
Mother of the petitioner is suffering from cancer, my lord. Interim bail, my lord.
So then it takes time now. You take just here.
Your Lordship has mother of the petitioner is suffering from cancer, and your Lordship has fixed this matter for today. It was inadvertently mentioned to 20th September. For
You
which
might not have appeared the other day.
No, yes, I have appeared. Your Lordship has fixed.
How it has gone automatically?
No, 20th September in
We'll see, you give the bail. Bail I'll not give.
No, interim bail. Interim bail. It is for interim bail.
We'll see. Okay. Yes.
But to make mention, my lord, 3 bail application, my lord, specifically adjourned the 14th August, my lord.
Bail matters, it will come automatically. Don't worry.
Petitioner is in custody.
Minor mention,
1.5 year.
You give the bail application. I am not going to give any preference if you come serially.
My President 19.
Give all these things. All the matters will come serially.
May I please, your lordship? Malicious item number 13. It's an appeal matter of 2006. What's the date in this?
13. Let it come. We'll see.
Malicious.
my lord. May I mention, my lord? It pays 10 item 66, my lord. On the bus.
90.
92. Page
You want
60.
adjournment? 1 minute. Yes.
92, your lordship appointed amicus curiae because on that day nobody appeared.
Right.
He along with his associates have filed power on behalf of the appellant.
Oh.
It is ready for hearing. Paper book has been,
Come, we'll see.
let it come in the weekly hearing list.
We'll see.
And their power may be reflected. Amicus curiae name may be deleted in their
Nobody
power.
came, I appointed amicus curiae. This is very embarrassing for an amicus curiae, you know. He prepares and everything, and
He should not have filed a wakalat.
once this is a minimum thing, you know. Once amicus curiae is appointed, we can't.
My learned friend Mr. Mishra was appointed amicus curiae.
So in many cases this happens. Nobody comes. I appoint amicus curiae. Thereafter, all of a sudden comes.
Lord,
There is-
once the court appoints somebody as
That's right.
amicus,
That's
a wakalatnama should not be entertained.
that's right. But
Their
it is-
power may. Their power may.
Generally, the registry should decline. Once appointed, how can you know? This is an embarrassing situation for the amicus curiae also. He prepares and everything, and
It's embarrassing for everybody, for the court also.
It will come on the weekly hearing
We'll
list,
see weekly list. Will
indicating the
weekly
name.
list. You put it in the weekly list. We'll see. Yes.
117.
My
117. What happened?
That, my lords, there are 3 appeals together. If your lordship fixes a date or a time, they can all be taken up.
You know, time lost its relevancy now.
I have prepared a written note also.
Okay.
It's not a big matter also, it's a small matter.
May I mention it? It pays 10 item 66, my lord.
Let us wait for a day or so. Let us see how it moves.
Mark.
Otherwise, I'll fix a time so that we can
Okay,
finish it up. That's a better idea.
Mark.
Let it be there in the board. We'll see how things are moving. Because again, today the
I
assignment
understand.
has increased. Yes. Yes.
One small prayer.
My lord,
Yes.
may I mention, my lord?
Appeal.
My lord,
I'll let you finish. He's.
may I mention item 66. So defecting pointers are being removed in last Saturday. You need to be adjourned. Next week, we will comment this. Item
66.
six.
You want an adjournment?
You wanted adjourned because defect they were already been removed on last Saturday, but it's not been listed.
Adjourn for 2 weeks. Okay.
1 week after, my lord.
You remove the defects, whatever
I
defects.
already removed, my lord, last Saturday.
Let it come after 2 weeks, we'll see. Yes.
My lord, one criminal appeal matter. It was being heard by your lordship, but because the counsel appearing for vigilance, he was ill, therefore it could not be completed, my lord.
Yes.
My lord, the difficulty here is, my lord, the person who has been convicted, the wife is now prosecuting, my lord. He has expired, leaving behind the wife and the 2 minor children. They are suffering, my lord. They are also not getting in, my lord. At least, my lord.
I know, this is the
The
consequence.
difficulty is that, my lord.
we'll see, when we can accommodate.
My lord, 289 of 2018.
It is, I think.
Criminal
it-
appeal.
It's a parted kind of.
It was hard in part.
Yes. Let us start. Let us start. Right from 27. 127. Okay. Yes, no instruction. Dispose of, huh? The land counsel for the petitioner submits and files a memo that he has no instruction of the petitioner, hence the petitioner is disposed of.
28.
Yes.
Your Lordship.
Yes, madam.
It's a compromising matter, but the victim is not present here because of some personal difficulties.
Offenses?
My Lordship, 376 2N 363 and Bosco also.
You bring, I will not say anything. You bring the
calls.
letter, bring, we'll see. that thing.
Yes, my Lordship. My Lordship, may I urgent this matter for
I am
tomorrow?
just adjourning it. You bring them, we'll see whether it can be quashed or not. Okay?
Yes, my Lordship.
Okay.
My Lordship, for tomorrow, my Lordship. Okay. 29.
Yes. 29.
May please your lordship, may senior other court, so may possible.
Passover today may not be possible. I'll just simply adjourn it. Huh? What is this matter is about?
He has challenged the cognizance
Cognizance.
that is dated 11/1/2011.
2011 order you are challenging, there is no stay. Trial might have been concluded by now.
And my the prior portion, he has challenged that cognizance,
Yeah.
but actually that was not the cognizance date. That was the date of framing of charge.
There is nothing. See, 2011, much by now. 2011, see, for how many years? Just see, 1 decade. Cognizance order, there is no stay, nothing. I'll just pass it over. I'll just pass it over. Today I'll dispose it.
Sir.
It's unnecessary pending.
Obvious.
30.
30. What is this?
My lord, 307 was the FIR, he has not filed the joint affidavit. For us, my lord, kindly see the order dated
Hmm.
2/1/2023.
2123.
Then, my lord, subsequently it was adjourned from time to time, my lord.
Petitioner opposite party shall file joint affidavit to nobody comes also.
Madam?
They've said that they've settled the dispute.
Let's settle. Joint affidavit was directed to file joint affidavit. I1 till 24 time was taken.
Right.
17/1 time taken. 7/3 time was taken.
Right. On this matter was taken up on 2/1/2024, where the parties jointly informed the court that they have settled the dispute. And requested for filing joint affidavit. This court directed the parties to file a joint affidavit before the investigating officer, who shall verify and communicate the same to this court. Thereafter, the matter was listed on 5/1/2024, 17/1/2024, 7/3/2024, 2/5/2024. However, the order dated, earlier order dated 2/1/2024 has not been complied, and repeatedly time is sought. Adjournment is sought. Today, when the matter is taken up, none appears for both the parties, and it appears that the petitioners are not interested to pursue the matter. Accordingly dismissed. Yes.
31.
Yes, sir. 31. Passing.
My lord, passing of proceeding 379, 447 and 51 OMC.
Except FIR, there is nothing. Anticipatory will reject it.
Anticipatory will, my lord, allowed, subject to verification of antecedent.
Therefore,
Then,
must be having some antecedent.
then my lord, interim to modify the order.
None appears for the petitioner. in the interest of justice, urgent to October, first week. Yes. 32. He has not filed anything here, except
I have verified from the website.
32, yes.
Allegation of cheating against the principal by the pass out students of Maruti Pharmacy College, Baragarh. And allegation is late.
And you know the student power, the democratically
They are
elected
showing
government of the country
they are
is,
showing their power, my lord. Now they are showing my
so
power,
the students
Now-
have rightly done things.
my lord. So
You are for
in
the management.
In the meantime, my lord, a compromise has already been effected, and
The students.
with the students, and they have also filed the affidavits before your lordships.
Yes. Are you for the
Lordship, I am appealing to the informant. Lordship, the matter has been amicably settled. We have already got our
But
certificate.
how many students have given the complaint? Who is the
Nine numbers of students.
Huh?
Nine number of students.
No, let us see who is the author of the fire.
Author, my lord, opposite party number.
2 to 9.
You bring them.
Why should your lordship?
No,
Kindly-
in absentia. See, they are not doing any grace to the court. See, they are accused. They have to be here. Accused has
Principal
to be
is
there.
the accused, my lord.
Oh, the principal, let it be.
Principal is the.
But see, there is an FIR. You are causing. At least affidavits are filed,
My,
and we don't know the affidavits are procured or whatever. They should come and say that yes, this affidavit is filed.
Lordship,
That's it.
Lordship, they have
Ask
been,
them, at least through VC, let them appear. If they have any issue to, come to the court, let them appear. I'll put it next week, next week.
Lordship, Lordship, they have already filed it before the oath commissioner. They are staying.
You know what kind of oath commissioners are there around?
Let-
Let them appear. See, 9 of you are there, 10 of you are there.
Lordship,
Nine,
nine-
nine.
9 of you are there. At least 2, 3.
Lordship, that.
If not all of them, at least 2, 3 students should come and say that yes, we have no grievance against our principal. I'll cause it. No problem.
Lordship,
Okay.
grateful.
And next week I'm putting it through VC. Let the principal appear through VC. He need not come. Okay, but student can come. If they have the daring to file an FIR against the principal, they should visit the court. See how things moves against the principal. Call them. The student should be here, and the principal will appear through VC. Okay. Call them. Okay. Yes.
My lord, may kindly see.
33. 1 minute. 1 minute.
My lord, the date will be fixed.
Oh, date he is fixing. Give the date.
Next week.
Next week, any date. He'll give it. Yes. Yes.
My lord, may kindly see the order dated 2/5/24.
2/5/24.
Yes.
Yes.
My lord had
The
issued
council of
notice.
petitioner submits that the petitioner would be moving an application before the issue notice. Yes. What happened?
My
Service?
lord, the noting your lordship may say neither AD nor the undelivered notice has come back. She has received the notice. Received the
Let
notice.
us wait.
My lord, here what has happened? Yes, your lordship. Here what has happened? A divorce application was filed. During pendency of the
You
divorce
are the husband.
husband. During pendency of the divorce application, 125 was filed. Interim arrangement made confirmed by the Honorable Apex Court. In the divorce, permanent alimony was granted 17 lakhs,
Which you have paid.
which I have paid. She questions that in appeal. Now is she wants to put execution after the judgment passed in the divorce.
That permanent alimony you have already paid.
Yes, I have given the documents.
That is the reason I have issued
Yes.
notice. And
My lord, now she is not appearing deliberately. Your lordship may stay the proceeding, she will automatically appear in the next.
no, I have stayed.
Let me that, I'll file adjournment. Your lordship may stay.
I'll just put it next week. I'll just decide the matter. Same arrangement next week. Despite though the AD card and AD and
Undelivered notice.
Huh?
Undelivered notice.
Undelivered notice and AD card has been received by the office, but
No, nothing has been received.
Huh?
Neither AD card nor undelivered
the
notice.
awaiting service कर देंगे. Awaiting service on respondent number 2. Leave the matter next week. Next week. And the interim arrangement made on 2/5/2024 shall continue till next week.
There are two judgments of the Apex Court which I will show. Once
I know that permanent alimony is given, the maintenance also you can't insist for.
No.
I know that. If that is the case on facts, then I'll have to.
My lord,
proceed.
after seeing that only your lordship was inclined to issue notice. Any day next week date maybe.
Next week he'll give. Yes. 34. Yes. Yes, sir. 34. Who is appearing? See, no urgency, no urgency for the more. Non-APS for the petitioner in the interest of justice urgent. So, October 1st. Yes. 35.
Yeah. The petitioner had filed this just to quash the proceeding, my lord. In this case, my lord, the co-accused has been faced this trial and he has been acquitted.
NDPS.
My lord. It would be evident from the judgment that Section 100 sub clause 4 of the CRPC, Section 42 of the NDPS Act, Section 57, Section 55 of the NDPS has not been complied. It can clear mention in the judgment also, my lord.
You are one of the co-accused.
My lord.
The other people have been acquitted.
My lord.
That person who has been acquitted, he has no relation with the, he was the present at that moment only, and he was stitching some cloth.
Recovery is
But
made from this
house.
This accused.
Yes. Is the accused from where recovery has been made?
See, the statutory compliance qua that petitioner might have not been done. So therefore they were acquitted. In your case, the trial court has to see it. Whether the compliance qua you has been done or not.
Matter clearly mentioned here, lordship may kindly.
Mention is that is
I
that case.
I don't know whether you are arrested from the spot or they were arrested from the spot. You might have been arrested separately.
No, he was not arrested.
You don't know anything.
I was not present.
Then I don't know. How can I quash like this?
Yes.
Unless you can't get parity. When are you going to appear? You tell me.
My lord.
You appear. I'll protect you till then and.
Well, I am on bail.
Then you can't appear.
I have appeared, my lord.
Then face the trial.
Trial, yes.
You can't get benefit of this judgment in NDPS. Sorry, what to do? I can only do one thing. I can expedite the trial. You think over tomorrow?
But can it taken over next week?
Next week will not change. Tomorrow I'm placing it tomorrow. Tomorrow, list it tomorrow. Day after tomorrow. Okay, day after tomorrow. You seek instruction. I'll expedite the trial.
My lord, can it taken next week? I will take the instruction.
I
have no phone number, my lord.
We are not depending upon the instruction of your client because who is accused in NDPS case. I'm only accommodating you because you are not ready. I'm not accommodating for your client. Client is accused in NDPS case. Neither you are depending upon the instruction nor I. So you after tomorrow. Okay, next week. Next week. My lord.
Yes. Mate.
Here in this case, my lord, case of the year 2020, my lord.
You are seeking quashing?
Seeking quashing only early disposal of the GR case. That is my purpose, my lord.
FIR is for
2020. Charge sheet submitted. Cognizance was taken 12/5/2020 at page 5. Page 10.
No. How many witnesses? Charge sheet.
Charge sheet, my lord.
11.
7 witnesses are there.
This is the charge sheet. No, where from you got? See,
The charge sheet copy with me, madam.
7 witnesses. What is the stage now?
Now, cognizance was taken. That is lingering for disposal of the case.
No. Charge has not yet been framed. So how can I target it?
No, charge tribunal magistrate. Expeditious trial direct to within 2 months or 3 months.
No, 2 months. Charge has not been framed. I don't know how many accused are there. How many accused are there?
Accused, my lord,
11 for us.
देखिए दिले.
Huh? About 11 accused persons are there. And you are one among them.
Yes.
How can I expedite? I don't know what is the status.
As expeditiously as
Either how
possible, your
many of them
lordship.
how many of them are absconding, you tell me?
No, no, all are
I don't know.
41.
Yeah.
41, all have been.
Out of 11, you are only one.
One, my lord.
Suppose I
40,
expedite.
41A was compliant.
I'll
So far,
simply say as expeditiously as possible. That's all.
preferably with 3 months.
No,
or
no,
4 months.
preferably. I can't do that because I don't know the status.
I expeditiously, your lordship.
That is the, it will unnecessarily create a confusion.
Yes.
Okay. And petitioner is, petitioner has challenged the order dated 12/5/2022, whereby cognizance of offences under section 269, 270, 188, and 34 IPC has been taken against him along with other 10 accused persons. Other 10 accused persons. Learned counsel for the petitioner submit petition. He is only praying for early disposal of the trial, which is trial. Since only the cognizance has been taken by the trial court as yet, and even the charges have been held, so it won't be proper for this court to fix a target in the trial. However, needless to say that petitioner being an accused is entitled, constitutionally or statutorily entitled for a free, fair, and speedy trial. Therefore, it is expected that the trial court shall do well to see that the trial is concluded as expeditiously as possible. With these observations, the petition is disposed of. Yes.
Obliged.
37. 37 regular appeal, 2 years
2 years
imprisonment.
imprisonment.
So,
Yes, bail granted, realization of is stayed, admit and list into weekly list, LGR is called for. Yes.
to reflect the name.
Any other accused?
No, only one
only
accused.
one.
Reflect my name in the cause list as well as on the top of the brief.
That is that.
And my prayer before your lordship that item 93 is likely to be passed same order. 93. Your lordship may kindly have a glance. Press admission.
93 also same order. Sentence same.
3 years.
3 years.
Misappropriation.
But let the petitioner's counsel.
So I have
You may go. You may
93.
Same 93 also. Mr. Das number and all.
It has been written for admission.
Yes. 93 I'll record here.
Yes. To reflect in the top.
Yes.
Top of the brief as well as.
But let him come.
Yes.
38. Certain infrastructure on the trial complete.
Become infrastructure.
Infrastructure. Thank you. This is the best thing which could happen. Infectious. Yes.
39.
May I please
39.
check? I may be allowed to appear virtually, Lordship.
Yes, madam.
Lordship, in the last occasion, you have directed for the statement of the victim where the victim and the accused both are age, Your Lordship.
Last.
I'm not sure I understand.
Somebody is saying something.
No. My lordship directed that a victim was examined as PW.
2, Your Lordship.
PW3. So
Wanted to
that
see that.
deposition copy may be supplied.
Where is that deposition copy?
Deposition copies,
Have you filed it?
no, Your Lordship, I have sent it to the court.
That is
Your Lordship.
164 statement.
This is
164.
164.
164.
Your Lordship,
This one which you have given this is the deposition.
yes, Your Lordship, that is what I have received from the
No.
court, Your Lordship.
Recording of the statement of the victim.
164 statement. This is. You filed deposition.
Oh,
Why have you not filed? I don't think you are interested.
No, Your Lordship. I just received it in the morning, Your Lordship. That is why I'm unable to.
Then
By
why
the
don't you go to trial court? I'll observe that you renew your bail application.
My lord, out of 21 witnesses, statutory witnesses, 14 witnesses were examined as on 8/1/2024.
8/1?
2024. 14
there-
witnesses have already been examined.
By that time.
By that time.
And what about the victim?
Victim is examined as PW3. What happened if petition is a juvenile? Your last occasion, Your Lordship wanted to know that
if he's a juvenile, then he's entitled. Right. You just file it. I'll put it next week. Okay. Don't delay it. Okay.
Definitely, Your Lordship. Published.
40.
Maybe 762 and 506.
Yes, sir.
Last one directed to corporate 164 statement. Certified copy of the 164 statement of the victim. We aged about 21 years minor. And present picture inside person.
Your custody since
21/10/2024.
21/10?
20 person since
10/1/24. Okay. You read it. Relevant part. Don't read the full. Have you given a copy to him?
Yes.
Read the relevant part.
गत वर्ष 19/23 ମୁଁ ମୋର କାକି ସହିତ ବ୍ରାହ୍ମଣ ମରାକୁ ବାହାଘର ଭୋଜି ଯାଇଥିଲି। ସେଠାରେ ମୋର ରାଜା ଗଣନାୟକ ସହିତ ଦେଖା ହୋଇଥିଲା। ସେ ମୋତେ ମୋର ଫେସବୁକ୍ ଆଇଡି ବତାଇଲା ଏବଂ ଆମେ ଫେସବୁକରେ କଥା ହେଲୁ। ତାପରେ ସେ ମୋତେ ତାର ହ୍ୱାଟ୍ସଆପ ଏବଂ କଲ୍ ନମ୍ବର ଦେଲା।
They were in relationship.
But betrayed.
Betrayed. What is her age?
21.
She is 21 and this boy is 24. Boy is 24. She is 21.
Now
they developed a relationship through Facebook and all.
You want to marry to some guy and what is?
And grant bail, then let us petition rejecting also. Her the victim statement. Don't write the name of victim. The victim's statement under section 164 or CRPC was recorded by the police. She in her statement inter alia alleged that last year on 19/1/2023 she become friend with the accused through the Facebook, and they become friends thereafter. On the in the year of in the month of March, the petitioner accused asked him to accompany to go the match. He voluntarily accompanied her, and subsequently the she was taken to where she was taken?
To Raurkela and Puri. And medicine was given for the termination of the pregnancy.
And where he was the petitioner pursuing physical relationship with her, and also promised to marry her. Subsequently, since he had wriggled out of her promises, the parents arrested. The petitioner is in custody since 10/1/2024. Yes.
Medicine was given her for the termination of the pregnancy. Medicine was given her for the termination of the pregnancy.
When she becomes the parent, once she becomes when she becomes pregnant, the petitioner administrates some medicine for the purpose of the pregnancy. Yes. 41. The victim is 21 years old and the petitioner accused is 24 years old. Give it. Okay. Next.
May I please, Rosh?
The offences under section 302, 201, 34 of the IPC. The petitioner number was in custody since 12/11/23.
CD,
Yes, CD just now I received the CD, madam. Just
You
now.
want to
That's
just,
CD.
you want to just read it?
So, madam, that is to be verified. madam.
Okay. Next week.
Can I pray, Your Lordship? The petitioner number 2 is unbail.
Huh?
Petitioner number 2 is on unbail, Your Lordship. Can I pray for the illness report from the jail in the
Let
meanwhile?
him see if you are entitled for bail, what interim bail. I will grant the regular bail. Why do you worry?
Much.
Let us see. Let him read first.
Much. Can I
Yes.
pray for a shorter date?
Yes.
Much shorter.
42.
42 withdraw. 42 withdraw. Yes.
43.
42, there are two bail.
First one withdraw.
Madam, 42?
42, first one is withdrawn. There are two matters.
Madam.
That is the 2148 is withdrawn.
Madam.
Okay. 2848. And what about the second one? 2177. 2177? 2177. He is withdrawing executed or what? Let's see. Executed, then same one. Simply bail as influences. They don't write why. Then I'll simply adjourn this second one. Second one simply adjourn. Non-APS for the petitioner. Adjourn. Yes.
43.
May I please, Your Lordship? Bail application, my Lord. My Lord, here there was a love affair between both, my Lord.
What are the offences?
Initially, it was registered under section 363, but charge sheet has been submitted under section 363 to 376 2N, read with section 6 of the POCSO Act. My Lord,
you are in custody since?
Custody since 12/12/2023, my Lord.
31. You are 31, huh?
31.
12/12?
2023, my Lord.
23. Okay. You are 31. And 164. So
164 statement is at page 14, my Lord.
read it out. What?
My Lord, I'm just reading
what was her age that time? 16.
16
years,
but it is more than 18, my Lord. Anyway, my Lord, people kindly look at the 164 statement.
Are you married?
I am prepared to marry, but I have
you are not married.
Not married, my Lord. And I want to marry her, my Lord. There is a love affair.
Because you are in custody, therefore.
I am in custody, therefore I am unable
Therefore, you are interested to marry. Once you come out from the custody, you will not.
No. I will marry, my Lord. I will marry, my Lord.
Read
the statement, the relevant portion I will show to your Lordship, my Lord. Page 14.
Yes.
I am just reading the relevant portion. Talu 1, 2, 3, 4, 5.
Relevant part. You read.
The 8th paragraph, 8th line from.
Read it.
ତାପରେ ମୁଁ 2 ଦିନ ପରେ ତାକୁ କହିଲି ମତେ ନେଇକି ପଳେଇ ଯିବାକୁ ସେ ମତେ
how the relation started? You just show
relation started, my Lord, because she had
read it.
Yes, my Lord, I will read the entire thing, my Lord. ମୁଁ ଏଠାରେ ଉପସ୍ଥିତ ରହି ବୟାନ ଦେଉଛି ଯେ ମୁଁ ଅଷ୍ଟମ ଶ୍ରେଣୀରେ ପାଠ ପଢୁଥିଲି। ମୁଁ ଗୋଟେ ଦିନ ମୋର ଆଈ ଘରକୁ ଯାଇଥିଲି। ସେଠାରେ ଉପେନ୍ଦ୍ର ଲିମା ଆସିକି ମତେ ପ୍ରପୋଜ କଲା। ମୁଁ ତାକୁ ମନା କରିଦେଲି, ସେଥିପାଇଁ ସେ ସେଠାରୁ ପଳାଇଲା। ତାପରେ ମୋ କଥା ମା ଜାଣିଲେ, ମତେ ମାରପିଟ କରିକି ମତେ ଆମ ଗାଁ ଆମ୍ବାକୁ ନେଇ ଚାଲିଗଲେ। ସେଠାରେ 3 ବର୍ଷ ରହିଲି। ଆଉ ଥରେ 5 ମାସ 3 ବର୍ଷ ରହିଲି।
8th standard she was studying after 3 years.
3 years she stayed outside. ଆଉ ଥରେ 5 ମାସ ତଳେ ମୁଁ ଆମ ଆଈ ଗାଁକୁ ବୁଲିବାକୁ ଆସିଲି। ସେତେବେଳେ ମୋର ଉପେନ୍ଦ୍ର ଲିମା ସହିତ କଥା ହେଲି ନାହିଁ। November 16 ତାରିଖ ଦିନ
last how the sexual relationship you
my Lord, ତାପରେ ମୁଁ 2 ଦିନ sexual
where is that?
Page 24. 24, that is column hymen column 1 2 3 4 5, 5th column.
Yes, healthy so
no
hymen was not intact.
Old
what is this?
Hymenal tear of posterior 5 o'clock position.
Sign of recent.
No recent sign of recent sexual intercourse.
Yes, I think right. Petition is during the investigation, the statement of the victim under section 164 CRPC was recorded. She, in her statement, earlier stated that when she was studying in 8th standard, the accused petitioner proposed him to marry. This fact, when this fact came to the notice of her mother, he was taken to his uncle's place, in a different village, where she stayed for 3 years. After 3 years, when she came back, the petitioner started having contact with her, and eventually they had developed sexual relationships. The petitioner is agreeable to marry the victim. However, the parents of the girl is not getting trouble for
ବର୍ତ୍ତମାନ ରାଜି ହେଇଗଲେଣି ବର୍ତ୍ତମାନ ରାଜି ହେଇଯାଇଛନ୍ତି
trouble for them. I have also perused the medical evidence, which reads the medical evidence reads as under. Column 4 लिख दो. Hymen was not intact. Old hymenal tear at the posterior 50 o'clock position. 50 o'clock position. No sign of recent sexual intercourse. The petition is in 2020. Charge sheet, everything is filed now. Charge sheet is already been filed. Granted me.
victim ର statement ବି record ହେଇଗଲାଣି evidence ହେଇଗଲାଣି but she has turned hostile.
Okay, I am granting it. Okay, next.
ସେ ଯୋଉଟା ହଜୁର ଲେଖିଲେ uncles ଙ୍କ ଘରକୁ ଗଲେ uncle ର ଘରକୁ ଗଲେ ସେଟା ତାଙ୍କ ନିଜ ଗାଁକୁ ଗଲେ ବୋଧେ.
To his native place, uncle's place, in native place. Yes.
May I please, Your Lordship?
Yes, madam.
This is a case, my lord. Petitioner is under custody since 18 January 24.
18 January 24.
Yes, my lord.
Okay.
My lord, this is not an usual case of 376, my lord. Why I'm saying, Your Lordship would find out from the allegation, the investigating agency has mechanically filed the charge sheet under 376. My lord. This person, the petitioner, my lord, the informant party, one of the sister-in-law of the informant lost in the panchayat election in the last term. So, my lord, there was also a threatening in the FIR. जे आमर खर्च होइची 10 लाख टंका सेटा फेरे दियो नहले तम नारे मिछ रेप केस हम
The sister-in-law of the
so-called victim.
Victim.
Yes, my lord. Lost in the
Bhaujo. She contested with this petitioner.
With the wife of the petitioner.
Wife of the petitioner.
Now the wife of the present petitioner, no, she is the ruling sarpanch of the concerned Gram Panchayat. And
Show me 164 if you have.
That my friend can say.
My lord.
Yes, 164.
ମୁଁ ସୁଷମା ସାହୁ 2 ଦିନ ତଳେ ରାତି ପ୍ରାୟ 10ଟା ବେଳେ ମୁଁ ମୋର ଘରେ ଶୋଇଥିବା ସମୟରେ ଆମ ପଡ଼ୋଶୀ ପ୍ରବୀଣ ଦାସ ମାଇଲର ପିଟିସନର ମୋର ଘରେ ଶୋଇଥିବା ସମୟରେ ପ୍ରବୀଣ ଦାସ ଆମ ଘର ଭିତରକୁ ଲୁଚିକି ପଶିଗଲା ନିଜର ପରିଧାନ କରିଥିବା ବସ୍ତ୍ରକୁ କାଢ଼ି ଖାଲି ଦେହ ହୋଇ ମୋ ପାଖରେ ଶୋଇପଡ଼ିଲା ଏହାପରେ ମୋର ବସ୍ତ୍ରକୁ ଜୋର ଜବରଦସ୍ତ ଟାଣି ଛିଣ୍ଡାଇ ଦେଲେ ମୋର ପାଟିକୁ ତାର ହାତରେ ଚାପିଦେଲା ଜୋର ଜବରଦସ୍ତ ଦେଲା ଏହାପରେ ମୁଁ
I'll just look at the nature of a crime, and accordingly we'll see modify the what you call Shall I grant the bail saying that he will appear in the police station every week?
Let her file, because my lord, I know that the victim is under threat. Let her file an affidavit. Your lordship may consider and pass.
And we will bound down.
One thing may I pray, my lord, may I just submit. There were 8 to 10 people attacked me.
That is after the incident.
Undressed this petitioner and beaten him and thrashed him with iron rod. He, my lord, sustained 16 injuries on his hand.
After the incident, villager. After the incident, villager assaulted him. That cannot be.
My lord, that counter case, all the brothers have been charge sheeted under 307 and other offences.
You have filed again.
Yes, my lord. So, and this petitioner, my lord, he had to undergo treatment for 4 long months. swallowed a stitch and a broken hand. Mari ki pokedan se moru vanchichi. And now they all are now bail, my lord, on bail. my lord.
Jail is a better place. Let him stay for some time. He'll recover for 1 week at least.
My lord.
Put it next week in the end so that Friday?
My lord.
Next week, Monday, Tuesday.
My learned senior friend.
No, you.
Yes, sir, I'll file.
Yes, put it Tuesday or Wednesday. You file the affidavit immediately, yeah?
My lord, my lord.
Okay.
45.
Yes, sir.
20B2C of the NDPS Act. 20B2C of the NDPS Act.
Yes.
Custody in custody since 9/3/2024.
9/3/24.
24 40 kg.
40.
40 kg already final charge sheet.
9/3/40. Conscious position.
Final prosecution report, nothing adverse as per the instruction of the.
No adverse.
No adverse. Nothing adverse, my lord.
That will grant the bail. Subject to verification of antecedent.
No,
Subject to verification of antecedent.
But here the instruction.
That's the common order we'll see.
Subject to verification, my lord.
To bail, subject to verification.
Subject to
These in custody since 9/3/24. Similar case.
Similar case gotti achi one case 20B2B ro.
He says no.
Siye ko je mu jan mo na achi gote.
Recovery. What is the recovery in that case?
10 kg 10 kg એટલે 2021 2SEC case number 19 of 2021.
That's the problem.
On antecedent 20B2B.
That's right, but see, then recovery from your position. You remain in custody in that case for how many months or whatever? You
10 kg.
stay a little more. I'll grant you bail. Stay 3 weeks.
Pardon?
After 3 weeks, I'll grant you.
Already final case submitted.
That's right, but antecedent, the common order I pass. Generally, I pass this order.
No.
So I pass this order. If it doesn't happen, come again. Okay. That's a better idea. Because see, 37 is barred because you have been involved in more than one case. I can't pass a wrong order. I'll grant you the bail with that condition. We'll see what happens. Your job is done. Thereafter, again he will come. Grant bail. He is in custody from 9/3/2024. Recovery is 40 kg. Ganja. Grant the bail. Subject to verification of identity. We'll see. Yes.
46.
46 may I?
Yes.
The case of 302. Yeah, what has happened, my lord? The both of the petitioner and the victim, the deceased, they are auto drivers, my lord. Custody since my lord 3/11/2000. 3/11/2023. Charge sheet had already been filed.
Yes.
Since month of my lord February, my lord. And the only allegation that due to my lord some
CD is there?
Yes, CD is there, man.
Due to my
postmortem report, my lord.
regard to some order, there was an altercation of word and he gave a push. And this person who died, my lord, he hit himself in a iron gate. And he thereafter he was unconscious and declared dead in the. That is the only one Hokase age. That is the only allegation.
You have not used any weapons or any.
All statement are similar. Se taku gote khali podi dochi.
Accidental death kind of.
Accidental. Again. ମୋ ଭାଇ ପ୍ରତିବାଦ କରିବାରୁ ତାକୁ ଗାଳି ଦେଲା ଆଗେ ତାପରେ ମୋ ଭାଇକୁ ଧକ୍କା ମାରିଲା ସର୍ବ ଜାଣି ଶୁଣିକି ଧକ୍କା ମାରିବାରେ ମୋ ଭାଇ ପାଖରେ ଥିବା ଗୋଟେ ଲୁହା ବାରିକେଟ ଉପରେ ଜୋରରେ ଧକ୍କା ଦେଲା ଫଳରେ ଯେ ବାରିକେଟ ଉପରେ ପଡିଲା ତାର ମୁଣ୍ଡରେ ଆଙ୍ଗେଲଟା ବାଜିଗଲା ପଛରେ.
Some witness to the occurrence are there and they are stating that the Sharif Khan ଜାଣି ଶୁଣି ରୋଶନ କୁ ମାରିବା ଉଦ୍ଦେଶ୍ୟରେ ପାଖରେ ଥିବା ଲୁହା ବ୍ୟାରିକେଡ ଉପରୁ ଖୁବ ଜୋରରେ ଧକ୍କା ଦେଲା ଯାହା ଫଳରେ ମୋହମ୍ମଦ ରୋଶନ
Mario, he could have come with some armed or something.
And that cause of
accidental, what to do?
Accidental. Already.
And that cause of
show me medical.
Medical malord injury. First malord there was no injury mark. Detected body. And postmortem report says malord. Lacerated wound 4 into 1 cm into 5 cm is called deep.
In the-
belly. That got said.
Skull.
Right occipital
In the
region,
skull.
external and some internal injuries on the head.
Naturally,
that
naturally,
the external and internal
how
findings
many
are-
what about your criminal entity?
No one. No one.
Chalo. 311. Custody in 311, accused is so, and the allegation against the petitioner is that, where is the allegation, sir?
My lord, he gave a push. He gave a push to the my lord deceased. He hit himself on the my lord.
Where have you written those things? I just.
I have, my lord. I am. My lord, paragraph 3, I have written the
Paragraph
story.
3 of the petition.
Further, the president
And
petitioner.
how many witnesses?
My lord, there are
Eyewitnesses
witnesses, my lord.
from the CD. Just check it
Yes,
out.
CD, I am checking. 29 witnesses.
No, eyewitness I am talking.
Eyewitnesses only, my lord. Occurrence witness to I know no eyewitness.
No, occurrence witness. How many?
Three are
Three occurrence.
Three
Of the occurrence witnesses have also reiterated the.
Those who were, my lord, having stopped near that.
Yes, reiterated. Who are those who claim to be present at the spot have also stated.
Carry on.
Four court there. In their statement to the police under section 161 CRPC, that in fact there was a scuffle between the petitioner and the deceased, and out of in the fit of rage, the petitioner pushed the deceased pushed the deceased, as a result of which the deceased fell down, got injured as in his head, but in the steel gate. I have also produced the medical evidence which indicates that there is the death is caused due to the head injury. In the backside of the backside of the injury caused in the backside of the head, backside of the head. Since it from the evidence appears on the evidence on the record, it appears that it is a sudden out of fit of rage, the petitioner has pushed the deceased, as a result of which the petitioner, the deceased has died, and the deceased was not armed. So therefore, it is difficult to impute motive intention to kill. He is in custody since 3/11/2022 and with additional condition. Additional condition is not. Yes.
May. Here is the 20 BI NDPS, sir. 20 BI custody 16/9/2023.
16/9/23.
Yes, madam.
Yes.
And ganja recovery from the house of the
how much
petitioner 155 kg.
Huh?
155 kg.
155. What is the position?
Charge sheet submitted, manager. For charge sheet submitted.
Recovery from his position.
Not position.
Then and the antecedent part is there, manager.
House of the
about the character antecedent accused person, record and ascertain that prior to this case, he had no criminal records against him, my lord.
No, recovery from that.
Recovery, my lord, that is a
conscious position or not?
Conscious position, my lord.
Yes, so.
And that a vehicle is, he is the owner of the vehicle, my lord.
House of the petitioner recovery. And two brothers are also not named.
Put it next week. Next week. Just read it.
My lord.
That's only conscious position or not?
Yes, yes, my lord.
Yes.
May I plead your lordship?
48.
Yes, my lord.
Yes.
In the meantime, the victim examined as BW1 million, that is running annexure to running page 13. He does not support the prosecution. Rather, my lord, she stated that she had love affairs with the petitioner.
Yes.
And she wanted to marry her. And due to interference of the doctor and police, he lost this case against the petitioner. That is my lord.
Victim girl.
Yes, my lord.
Where is that?
That is 13, my lord. Annexure 2.
In the court, huh?
Yes, my lord.
Let us see.
Placing the relevant portion, my lord. Paragraph 1. The occurrence took place 6 months back. By that time, my marriage with the accused was fixed, as we both are in love.
Where are you reading?
Paragraph 1, running page 13. Deposition of
Okay, okay. I'm the victim.
Yes, my lord.
I know the accused person.
The occurrence took place 6 months back. By that time, my marriage with the accused was fixed, as we both are in love. The accused used to resided in my house, so also I was residing in his house.
19. What is your age?
28, my lord.
Yes.
My victim at the time of occurrence, 16 years.
Oh,
not
that's
16
right,
years.
but we did not support the prosecution.
No, my lord, that is the one in her 164 statement, my lord.
No, I have now in the court, she came and
Already.
Annexure 2.
he says I was in relationship and all.
Oh,
all
the
these things.
in her deposition copy, my lord.
Just see Annexure 2. Have you read?
That
Have
copy
you
is
seen
not
it?
with me.
Annexure 2.
Oh, sorry.
Just see, check it up. You want to verify it, then I'll put it, I'll pass it over. Or tomorrow. Let it be
Yes, my lord.
Yeah, tomorrow. Let
Madam,
him just see tomorrow. And the girl had not supported the prosecution, what to do?
My lord.
Preparing for the
You are
victim.
in custody since?
Custody since, my lord. 6/9/2023. Informant also appeared, my lord.
20?
Yes, my lord.
Yes, what do you say?
My lord, I am appearing for the victim, my lord. Informant
nearly 2 years, my lords. And my lords, the offense is 302 IPC. The sheet has been submitted.
Yes, it is there.
And the basis of implication, my
Update sheet
lord.
is not there, my lord. Up to date sheet is not there, my lord. Up
My
to
lord, charge sheet
22,
has been-
12/22, my lord.
22?
12/22. That case diary available, my lord.
Let's
Counsel
one
for the state submits that up-to-date case diary is not available. Hence, he seeks 1 week time to obtain the up-to-date case diary. Lease the matter after 2 weeks. Yes.
My lords, one thing, my lords.
Let him get the CD. Huh?
My lords, in the meantime, some witnesses have been examined, my lords. So I am submitting the deposition copy to the honorable court, so also to my friend appearing for the
Yes,
state.
yes.
That may
Do that.
that's
better.
That may be
That's better.
taken on record.
And then if see your bail application was rejected, it was yes, your bail application was rejected on February 2024. Thereafter, any witnesses are examined?
February 2024. No, all these are before that. Before that, maybe some more may be examined. I don't know, but whatever I know,
Okay,
my
let
lords,
him get.
I have
Now,
served 7.
would you like to repeat your bail application before trial court?
My lords, I have a very good case, my lord. The basis of implication is only
I
the
will give you liberty because the rejection of your bail application, the trial has proceeded. So therefore, on the basis of the fresh evidence, the trial court can decide your bail application afresh.
My lords, when the rejection order was passed, my lords, by that time witnesses were examined. The rejection order shows that was taken on my lords. So, my lords, the deposition copies may be taken on record kindly,
Yes,
my lords.
deposition copy, the learned counsel for the petitioners seeks to place on record the deposition copy of the witnesses. Let him do so. In the
And
meantime.
copies on
You
state also.
file it and
Already served to the state. Already served to the state. And lords, you kindly fix a date.
Already been served. Yes.
Lords, you kindly fix a date, my lords.
No, he's fixing date. Yeah. All the matter date will be fixed. Don't worry. Yes.
Item 50.
50.
My lord, may kindly urgent to argue. Senior will argue this matter.
Offense 307. You are in custody since?
My lord, I have no file yet.
It will go to October only. First week of October. First week of October.
51.
Yeah.
Initially, my lord, offense under 363, subsequent on to 366, 376(3), 376(12), and 6 of a postcard to my lord. The personal custody since 25/1/2024 आज्ञा। ରହିଲେଣି ଆଜ୍ଞା 25/1/2024 ଆଜ୍ଞା CS submitted again 6/4/2024 my lord. Well, last occasion.
CD has come?
Yes, CD come. Last occasion, this is direct to call for the CTC and statement of the victim and notice the victim. Already victim appeared. My friend.
Who is it? Who is appeared?
Perhaps this is I've already listed.
Balangir DLS.
He is appearing? 51? You are appearing?
Yes, my lord.
Acha. Yeah, yes, what 164?
164.
What do you say?
Victim repeatedly said she was 14 years old and his consent is no consent, though in 161 it was recorded. So if a young chap has no.
This boy is also 20-year-old. That's the problem.
Sir,
he was 15, this boy is 20.
Sir, another 4 years to go for her marriage.
My statement.
1 minute. Yes.
And my lord, medical examination report, my lord, says there is repeated sexual intercourse, my lord. 13 years girl, my lord.
Concern, nothing is there to that extent. I am producing the certified copy of that medical report. May kindly see.
164?
164 is not.
164 আজি 13/23 এই বয়ান দଉଛେ ଆଜି ସକାଳେ ମୋର ସ୍ୱାମୀ ଆଉ ପୁଅ ବିଲକୁ କାମ କରିବା ଗଲେ ମୁଁ ଏକୁଟିଆ ଘରେ ଥିଲି ଘରେ ଥିବା ସମୟରେ ସକାଳ 11ଟା ସମୟରେ ଆମ ଗ୍ରାମର ସୁଭାଷ ଘଡାଇ ପିଟିସନର ଘର ଭିତରୁ ବସି ମୋର ଇଚ୍ଛା ବିରୁଦ୍ଧରେ ମୋ ସହ ଜବରଦସ୍ତ ଶାରୀରିକ ରଖିଲା ମୁଁ ଚିତ୍କାର କରିବାର ମୋ ପଳେଇ
ଜବରଦସ୍ତି
ଲେଖିଛି 40 years old my lord.
ये medical?
Nothing.
Medical no.
When the incident had taken place?
13/12/23.
13/12/23. Medical?
15/12/23.
Huh?
15/12/23.
1 minute. Very medical when?
Stop.
What is the date?
15/12/23. Medical examination report of victim accused transaction number so dated 15/12/23. The beginning page.
There is no recent.
No bodily injury. Age of 40 years.
The petitioner is accused on so, and allegation against the petitioner is what is the allegation? You read it out. Tell me. 164 na?
Yes, most
statement. 1 minute. Statement of the victim under section 164 CRPC was recorded by the police. C inter alia stated.
Since mallet 1910 mallet.
1910.
1923.
Okay. What are the allegations?
The prosecution case is that mallet I am giving briefly mallet. The informant is the son of the deceased. He came and lodged the FIR that my father, he went to a BD shop with another his cousin brother and another person, and there he could able to get information that there is a BD खाइला समय रे तांका भितरे आउ जण गोटे मु स्टेटमेंट पढ दो जो लॉर्डशिप कैन
Tell me, I understand.
So there was a से BD खाइबा जण को धक्का मारले वन मोतीलाल को धक्का लागिला सेट तांका भितरे से गोटे चपड़ा मारला डिसीज्ड सेट तांका भितर पाटितुंड हवा समय आउ 4-5 जण जे तांका साइर सेमाने जाई पहुंची कि सेमाने ताकू धक्का फक्का मारले विधा गोइटा मारिले देन एलिगेशन दैट थमे ताकू मोटरसाइकिल बसई के आनिला समय पिटिशन नंबर 1 ही assaulted means a लाठी so ता पिठी रे 3-4 फार मारिला then mallet
then what are the overtake attributed to 2 and 3
लात गोइठा बोली तार एलिगेशन मो समति आउ टिके आसी छ डिटेल कह दी
this is enough for me
ना अछि आउरी एनफ रे मो को जी एलिगेशन 2
you want to get it complicated so that it
complicated मो कहू नै सिंपल कहीं 23/9/2 गंडगोल हला 23/9/2023
okay
संध्या 7 टाळे but thereafter he went to hospital the FIR was less than 25
died on 25
ना 24 तारिख दिन मरि गेछि त काहे कि मो एनएक्सआर 4 करि छी त FIR हवा पूर्वरु FIR पूर्वरु the informant who is the son of the deceased informant he UD case was registered in UD case in your lordship can
307 that time
no से टोटली गोटे अलग यूडी केस रे तार यूडी केस रे इन्वेस्टिगेशन आले तार इनक्वेस्ट पड़ले कहला मो बापा को देह भल नउतला छाती ହାତ ମାରିଲେ ପଡ଼ିଗଲେ ସେଠୁ ତାଙ୍କ ମୁଣ୍ଡରେ ଚୋଟ ବାଜିଲେ ମୁଁ ହସ୍ପିଟାଲ ନେଇକି ଆସିଲି ବାପା ମରିଗଲେ that is his statement running page 31 your lordship ମୁଁ ପଢି ଦଉଛି ମୋ ବାପା ମୋ ବାପା ବିନୋଦ କୁମାର ସାହୁ
UD case that the UD case is on 24
UD case ହେଲା 24 ରେ
24
ଆଉ
incident taken place on 23 UD case in 24 and FIR is in 25 in between 24 he makes a different story altogether that's what you are
କର୍ଣ୍ଣାଟକ ସେ କହୁଛି ମୋ ବାପା ବିନୋଦ କୁମାର ସାହୁ କାଲି ସନ୍ଧ୍ୟା 8:30 ସମୟରେ ହଠାତ୍ ମୋ ଛାତିରେ ଯନ୍ତ୍ରଣା ହେଉଛି ବୋଲି କହି ହେଲେ ସେ ଏହା କହି ଛାତିକୁ ଧରି ଛିଡା ହୋଇଥିଲେ ଏହି ସମୟରେ ଆମ ଘର ବାରଣ୍ଡାରେ ପଡି ଯାଇଥିଲେ ପଡି ଯିବାରୁ ତାଙ୍କ
ମାଡ଼ ହେଲା ପରେ ସେ ଘରକୁ ଆସିବେ ସେ ହେଇଥିବ
ନା ସେୟା ହେଇଥିବ ତାଙ୍କ ଭିତରେ ବୋଧେ ଗଣ୍ଡଗୋଳ ହେଇଛି
that time the son may not be knowing all these things so therefore the UD case she has given that story
no
and subsequently he might have discovered
he went to spot he knows everything
he was beaten up he went to the house the son sees
not only when say FIR allegation se bhi mote spot
these are very nitty-gritty I don't want to go
report
okay
let us see only one injury that is on the head only injury
yes
only one lacerated injury
what are the weapons
yes weapon is on stick that are recovered from the petition number 1 I am placing the one statement of one eyewitness
yes
then Paramananda CORAM
Paramananda CORAM
yes categorically stated
ପୁରାଟା ପଢି
ହଁ ପଢୁଛି ଗତ 29/9/23 ତାରିଖ ସନ୍ଧ୍ୟା 7 ସମୟରେ ମୁଁ ଆମ ଘର ଆଗରେ ଛକ ନିକଟରେ ଠିଆ ହେଇଥିଲି ଏହି ସମୟରେ ରେନ୍ସା ଗ୍ରାମର ବିନୋଦ କୁମାର ସାହୁ ହେମନ୍ତ ସୁନ୍ଦର ବାଲିଗୁଡ଼ା ବିଭୁ ସାହୁ ମିଶି ଗୋଟେ ମୋଟରସାଇକେଲରେ ଖୁଣ୍ଟିଗରା ପଟୁ ଗ୍ରାମ ଆଡକୁ ଆସିବା ସମୟରେ ଆମ ଛକରେ ପାନ ବିଡି ଖାଇଲେ ବିନୋଦ ସାହୁ ଆମ ଓଦାପଡ଼ା ଛକରେ ଥିବା ରବୀନ୍ଦ୍ର ନାୟକକୁ ବିଡି ମାଗିଲା ସେ ମନା କଲା ବିନୋଦ କୁମାର ସାହୁ ଟିକେ ନିଶାରେ ଥିବାରୁ ସେ ବିଡି ଖଣ୍ଡିଏ ପାଇଁ ଜିଦ୍ କଲା ତେଣୁ ରବୀନ୍ଦ୍ର ନାୟକ ବିନୋଦ ସାହୁ ଏହି ସମୟରେ ଆମ ପୋଡାପଦ ଗ୍ରାମର ମୋତିଲାଲ ମଲ୍ଲିକ ପିତା ସ୍ୱର୍ଣ୍ଣ କାହିଁକି ପାଟିତୁଣ୍ଡ କରି ବିନୋଦ କୁମାର ସାହୁ କହିଲା ତାପରେ ବିନୋଦ ସାହୁ ଓ ମୋତିଲାଲ ମଲ୍ଲିକ ପାଟିତୁଣ୍ଡ ହେଲା ରାଗରେ ବିନୋଦ ସାହୁ ମୋତିଲାଲ ମଲ୍ଲିକକୁ ପଛରୁ ଗୋଟିଏ ଧକ୍କା ମାରିଲା ଏଥିରେ ରାଗି ଯାଇ ମୋତିଲାଲ ମଲ୍ଲିକ ବିନୋଦ କୁମାର ସାହୁକୁ ଅସଭ୍ୟ ଭାଷାରେ ଗାଳି ଗୁଲଜ କରି ଲାତ ଗୋଇଠା ମାରିଲା ଏହାପରେ ଆମ ଗାଁ ରାଜେନ୍ଦ୍ର ନାୟକ ଧର୍ମେନ୍ଦ୍ର ସାହୁ and ରବୀନ୍ଦ୍ର ନାୟକ ପିଟିସନ ନମ୍ବର 2 ଉତ୍ତମ କୁମାର ସିଂ ମୋତିଲାଲ ମଲ୍ଲିକ ଓ ଲିଙ୍ଗରାଜ ଦାସ another ପିଟିସନ ମିଶି ବିନୋଦ କୁମାର ସାହୁକୁ ତଳେ ପକାଇ ଲାତ ଗୋଇଠା ମାରିଲେ ଓ ରାଜେନ୍ଦ୍ର ନାୟକ ପ୍ରେଜେଣ୍ଟ ପିଟିସନ ନମ୍ବର 1 ଗୋଟିଏ କାଠ ମେଡାରେ ବିନୋଦ କୁମାର ସାହୁକୁ ପିଟିଲା ଏହା ଦେଖି ମୁଁ ସେଟାକି ନ ପିଟିବା ପାଇଁ କହିଲି ତାପରେ ବାଲିଗୁଡ଼ା ଗ୍ରାମର ବିଭୁ ସାହୁ ଡାକି ମୋଟରସାଇକେଲରେ ବସିବା ପାଇଁ କହି ସେମାନେ ତା ପଛରେ ବିନୋଦ କୁମାର ସାହୁକୁ ବସାଇ ଗ୍ରାମ ରେଞ୍ଜକୁ ପଠେଇଲେ ଓ ହେମନ୍ତ
come to the medical
injury in the head injury milord
one injury only
and outing
caused by head injury caused by
it's lacerated injury
milord
1 minute
yes
caused by lathi
yes by lathi milord
then 2 and 3 I'll grant bail
milord
one let one be there okay 2 and 3 I'll get one where have you written the allegation
paragraph milord
which paragraph
paragraph 3 the allegation
petitioners are what about the other accused persons
milord they have not yet been arrested milord
you were waiting after getting bail
we have been arrested since ବର୍ଷେ ପାଖାପାଖି ରହିଲେଣି
right petitioners are accused also allegation against the petitioner Parathi occurrence witnesses
milord
eyewitnesses
Paramananda CORAM
how many
there are 3 witnesses
there are
eyewitnesses
there are 3 eyewitnesses and the eyewitnesses statement recorded under 161 CRPC was read over in the court which indicates that it is the due to the scuffle broke out on the date of incident all the accused persons have beaten up the deceased the petitioner number 1 has used what
made a stick
a heavy stick
which are recovered from his
heavy
house
stick, which was eventually recovered from
milord
recovered from his house
petition number yes
recovered from his house whereas the allegation against petition number 2 and 3 are that they have assaulted him they have beaten him
Bidha goita dele kick.
by kick and fist blow. Fist blow. Fist blow. These are in custody from 1910 to 2023. Since there are specific overtake attributed to petitioner number 1, which corroborates with the evidence of medical evidence. I am not inclined to enlarge petitioner number 1 bail. However, in so far as the petitioner number 2 and 3 are concerned, there is no specific overtake attributed to them. Hence, they are entitled to bail, owing to the fact that they are in custody since 1910 to 2023. 2 and 3 granted bail, rejected. Yes.
That is satisfied on 14 sessions about the matter.
14 sessions.
That commitment.
That is always. Yes.
54.
I please, my lord. Here the accused petitioner is in custody since 14/1/2024 on an allegation under POCSO Act.
Sorry, your custody since?
I am custody since 14/1/2024.
Yes.
Under POCSO Act. In this meanwhile, the police has already submitted charge sheet, and the trial court has already examined the father of the victim lady. The statement of the victim lady recorded under section 161 clearly reveals that she was a consenting party and had accompanied with the accused to different places. But this 164 statement, she has contradicted her previous statement under section 161 and developed something more new and alleged that there was force by the accused. My submission is that the court may please to see the father. I have already submitted the deposition of PW1. That is on record.
PW1 is the father of the victim.
My lord. The cross examination may be kindly perused.
Let us see 164. Let us see 164.
164 statement.
The victim says.
The victim says that there was the accused applied force and committed sexual intercourse. But if 161 statement,
you were in relationship.
Yes, the 161 statement clearly reveals that there was a love relationship between the accused and the victim lady. But the
what about 164? See, I'm worried about one thing. Your age is you are about 34 years old.
34
and the girl is only
17 years. And he is a married man.
For that reason,
you are a married man.
For that reason, I would like to submit that the deposition of father may be kindly be perused, wherein the father has stated specifically. So, for the age of the victim lady concerned, I would like to submit my lord that I cannot say the date of birth of the victim daughter. I admitted the victim in school. The teacher of the school estimated the age of the victim on her physical appearance and recorded the same in the school admission register. So, the father has admitted the victim lady in school, and he says that the teacher who got admitted the victim lady in the school estimated her age as per her physical appearance.
What about the victim has been examined?
No, victim has not been examined.
HSC certificate has been seized, my lord. There is age has been mentioned.
But what he says that the father deposes that he has not said what is the age. They looked at the physical appearance of the girl, and thereafter they entered a particular age.
That is there.
So he is disputing to that effect.
Yes. But when, my lord, HSC certificate available, then without going through
then,
that,
see, the documentary evidence speaks against you. The oral evidence of the father may not, help you.
The documentary
evidence. He is a married man, my lord, 16 years.
That's true. The evidence was created on the version of the oral evidence. The father is the competent person to speak about the age of the victim lady. My lord, my submission is that the father is
Rule 12. Rule 12.
My lord, that's true, but the documentary evidence is in favor of the prosecution. But the oral...
you wait till the victim is examined. I'm giving a direction to the trial court to examine the victim immediately.
Let the matter be fixed on some fixed date.
Yes, I'll do that. Right on. Petitioner is agreed by the order dated 4/3/2024, whereby his bail plea has been rejected. Mr. Nanaji, learned counsel for the petitioner, submits that the victim's father was examined in the court, who inter alia stated that looking into the physical appearance of the victim, her age was entered in the school register. So therefore, he disputes regarding the age of the victim. Apart from age of the victim, I have perused the evidence of the statement of the victim recorded under 164 CRPC. And there are specific allegations by the petitioner. Therefore, I am not inclined to enlarge the petitioner on bail at this stage. However, liberty is granted to the petitioner to renew his bail plea before the trial court after the examination of the victim. The trial court is directed to do well to see that the victim is preferentially examined before the other formal witnesses are examined. The same shall be done within 3 months hence. The petitioner is also given liberty to renew his bail plea after 3 months if would not be examined by that time. With this liberty, the petitioner is disposed of. Yes. Yes, 55.
302, 304B. Let it come next week. Okay, not next week.
Okay. Adjourn, none appears. Adjourn after 2 weeks. 302, na?
And 304B.
2 weeks, yes.
56.
Yes, thank you. May I please, my lordship? Please, my lordship.
Yes, Mr. Swami. Tamim.
My lordship. My lordship, it is a case under section 419, 420, 465, 467, 128, 34 of IPC, along with 66C and D of IT Act.
Yes.
The accused in custody since 21 January 2024.
21 January 24.
Yes, my lordship.
Okay.
21 January 24.
What are the allegations, sir?
The allegation is that the victim got a WhatsApp message. To WhatsApp message, they try to invest in the
name of giving part-time job, my lord.
Part-time job, my lord.
25 lakh some odd from the victim, my lord. Lied, my lord. This has been in 26 states, my lord. FR has been registered, my lord.
Against this
man. And my submission, my lord, rejected on 19/2/24. And charge sheet filed 14/5/24, my lord.
See, you are a very celebrity accused.
Yes.
No, sir. No, sir. My lordship, there is no transaction from my account.
26 cases in different states.
Yes. That is
My lordship,
will you pay back the money to the victim here? Because you have minted money like anything.
No, my lordship, I have no criminal antecedent like this against my, particularly against the...
Charge sheet again 14/5/24.
14/5/24.
Again.
The petitioner is agreed by the order dated 29/2/2024, whereby his application under section 439 CRPC has been rejected. During at that point in time, the investigation was still going on. Subsequently, on 14/5/2024, charge sheet has therefore, the petitioner, I am not inclined to. However, liberty is granted to the petitioner to approach the court of first instance by renewing his bail plea, as his earlier bail plea was rejected during the period of investigation, and subsequently charge sheet has been filed. With this liberty, the petitioner is disposed of. Next, yes.
57.
Again,
may I please, your lordship?
CD is there?
Again, CDW.
My lord, the date of occurrence in this case is on my lord 10th January 2024, my lord.
Offense 302.
306, my lord. Abatement for committing
custody since?
Charge sheet already filed, my lord. Since 11/2/2024.
11/2/2024.
11/2/2024.
Okay. What are the allegations?
Offense, my lord, 306 IPC. The petitioner, my lord, is stated, my lord, the petitioner was the businessman in respect of a small unit, my lord. And the deceased, my lord, who was working under him. Said, my lord, the petitioner was blackmailing the deceased because the deceased has love affairs with another girl, my lord, and subsequently by showing or sending the photo, she was blackmailing my lord and also extracting some amount, my lord. That is the allegations for which, my lord, she committed suicide.
He was working under you?
Yes, my lord. No, I was working under him, my lord.
You were working under the victim?
Yes, my lord.
Okay.
Deceased.
Tapu. Yes.
So, my lord, while she committed suicide, my lord, it is stated that present.
Your boss has committed suicide?
Yes, ma'am. My boss has committed suicide and the boss has complained against me, my lord, that I was blackmailing and I knew that my boss was in love with another girl, for which, my lord, I was showing the photograph of that girl.
Okay.
And I was blackmailing, for which he could not tolerate and committed suicide.
Your boss had relationship with someone else?
Yes, ma'am.
Which you came to know?
Yes.
You have been blackmailing?
Yes.
That's the allegation?
Yes.
And as a result of which she committed suicide?
Yes, ma'am.
Any suicide note, anything?
No.
Recovered?
And
yes.
The most important, my lord, she committed suicide on 10/1/2024. And the allegations on the date of, so your lordship said about this suicide note, on the date of allegation, on the date of her death, on the date of his death, my lord, he has made a statement before his sister that for these reasons I am committing suicide. This is on 10th January, my lord. But no FIR was lodged. No approach was made in the police stations. 1 month thereafter, my lord, FIR was lodged
by the sister of the
by the mother.
Mother.
And the mother knew that for my blackmailing, she
FIR
died.
dated?
FIR dated, my lord, 10/2/2024. ମାସକ ପରେ ଯଦି ସେ ଜାଣିଥିଲେ ମାସକ ପରେ କାହିଁକି FIR ଦେଲେ? This story was, and I mean, charge sheet has been submitted. I mean, custody since 306, my lord.
What happened in this case, my lord? Present petitioner sent some WhatsApp message, my lord, to another lady, my lord, to which this is there is marriage negotiation are fixed both with them, my lord. Achievement of one Rudranara Naik, my lord. Yes, categorically stated, my lord. ସେ ପିଲାଟି ଦିନରୁ ତାଙ୍କ ଘରେ ରହୁଥିଲା, ତାର ବିବାହ ରଶ୍ମିତା ନାୟକ ସ୍ଥିର ହୋଇଥିଲା। ଜୀବନର ସାଙ୍ଗ ଜୟନ୍ତ ମହାରଣା ପ୍ରେଜେଣ୍ଟ ପିଟିସନର ଓରଫ ତପୁ, ସେମାନେ ଦୁହେଁ ଗୋଟିଏ ଜାଗାରେ ଖାଆନ୍ତି ଶୁଅନ୍ତି। ଗତ 24 ତାରିଖ ଦିନ ବୁଧବାର ଜୀବନ ଘରକୁ ଫେରି ନଥିଲା। ରାତି ପ୍ରାୟ 11ଟାରେ ରଶ୍ମିତା ନାୟକ ଆକାଂକ୍ଷୀକୁ ଫୋନ କରି କହିଲେ, ତୁମର ଭାଇ ନହଙ୍ଗ ପଞ୍ଚାୟତରେ ବାନ୍ତି କରୁଛି।
It's all right. See, this boy is also 26 years old, all these things. Let him face it. Right? Petition is accused in so and so. The prosecution from the incident that happened. The deceased committed the incident that happened on 10/2/2024. 10/1/2024. Whereas the FIR was registered on 10/2/2024 after 1 month. After 1 month. It appears from the record that the deceased was the petitioner was working under the deceased, and the deceased and he came to know regarding the deceased with a particular individual. This aspect has been the petitioner has been exploiting his position to blackmail the deceased. It is also alleged that the petitioner has informed this fact to whom?
To his sister.
To his sister.
To one Rasmita Millard, with whom negotiation of the deceased was fixed.
Yes.
Rasmita.
That was
Yes.
Rasmita.
No, Rasmita is a girl. Rasmita is a girl. Marriage boy sang
Akanksha, my lord.
Akanksha, sorry.
She has the point of view.
Sir, yes.
To her sister on the date of incident, so immediately before the date of incident. However, the FIR came to be registered after 1 month. The petitioner is in custody since 11/2/2024. Charge sheet has already been. Therefore, I'm inclined to enlarge the petition on bail, enlarge the petition, and you will not influence that condition. Condition,
only state objection will be recorded. Only.
That state's objection, vehemently opposed. Yes.
On behalf of Kumar Mahanti, I may be permitted to press this matter, my lord.
Yes.
Here, my lord, that petitioner is in custody.
Yes.
Since 17/4/2023.
Yes.
And my lord, here alleged date of occurrence is 11/23.
11/4/2023.
And alleged offences are under section 363, 376 2N of the IPC reads with 6 of the POCSO Act, my lord.
Yes.
Here, my lord, case of elopement. That victim is aged about at the time of occurrence more than 17 years, more than 17 years. And my lord, that marriage proposal of the victim was fixed. For that reason, my lord, he contracted with this present petitioner who is aged about 27 years. And thereafter, my lord, they fled away. This is the, my lord, letter which has already been written from the house.
This is part of the
CD, part of
not a part of CD.
But my lord, that letter was given to me.
Then no, how can I consider part of CD? Let us see.
Yes, my lord. But my lord, the rejection of that affair.
Are you ready?
My lord,
are you ready or put it tomorrow?
Ready, my lord. Let him place me. Yes.
Yes, my lord. My lord, can I have a glance to the affair, my lord?
164 show me.
Yes, I am placing that 164.
164.
ମୋ ପାଖରେ 164 ନାହିଁ କିନ୍ତୁ ଏଫଆଇଆର ରେ ସେ ନିଜେ କହୁଛନ୍ତି ତାଙ୍କ ବାପା ଯେ ମୋ ସହିତ କଥାବାର୍ତ୍ତା ହୁଏ ଆଉ ମୋ ନାଁରେ ବି ଏଫଆଇଆର ହେଇଛି ତାର ଲାଷ୍ଟ ପୋର୍ସନ୍ସ ଅଫ ଦ ଏଫଆଇଆର ମାଇ ଲର୍ଡ କାଇଣ୍ଡ ଅଫ ଏ ଗ୍ଲାନ୍ସ ଦ୍ୟାଟ କିନ୍ତୁ ମୁଁ ଜାଣିବାକୁ ପାଉଛି ଆମ ଗ୍ରାମର ବିନୁ ମଲ୍ଲିକ ସହିତ ଏହି ନମ୍ବର ଫୋନ ନମ୍ବର ହଉଛି ସୋ ଆଣ୍ଡ ସୋ ରେ ସେ ସବୁବେଳେ କଥାବାର୍ତ୍ତା ହୁଏ ତେଣୁ ଆପଣ ମୋତେ ସହାୟ କରିବେ ଏବଂ ମୋର ବିଶ୍ୱାସ ଆଜ୍ଞା ମୋ ସାଙ୍ଗରେ ସେ କଥାବାର୍ତ୍ତା ହୁଏ ବୋଲି ତାଙ୍କ ଘରେ ସମସ୍ତେ ଜାଣିଛନ୍ତି
Admittedly, my lord, victim is 70 gas, my lord. I am placing her 162 statement. आज 11/4/23 तारीख रे मु अभिमन्यु सामंतशिकार कॉलेज को जाइथिली से गाड़ी रे नहीं कॉलेज रे छाड़ी आसिले तेई दिन 12:30 रे मु घर को चली आसिला बेले मनोज मल्लिक प्रेजेंट पिटिशनर my lord बाटरे देखा ले मते परे छाड़ देबा पे कहले से मते महांगा आड़ू को नहीं गले मु बापा को फोन करिया को चेष्टा कली बेले मो फोन नहीं गला और से मते तार माउसी घरे रखिला और तांको माउसी घरे केही नथिबारु से मो सहित जबरदस्त शारीरिक संपर्क रखिला तो my lord 17 gas my lord date of birth documented evidence available my lord category against her will and consent my lord present petitioner abuse of authority and
he has some document to show that
that is not a part of this 164 I am placing my lord then my lord medical exam report yes there is recent sexual intercourse
my lord my humble submission before your lordship my lord whether is it possible without the consent of a lady
I don't know
one can shift
his father
that the lady only can say who has said
by a bike my lord
rejection order so my lord his mother and father has
any other any other material where some help can be rendered to the
no his shows my lord his mother and father has been examined my lord he has not direct him to examine my lord victim my lord
victim exam he said rejection order itself indicate my lord can I glance to the rejection
of victim
rejection order my lord that paragraph 8 that on perusal of the case record it reveals that rejection order my lord
then for the petition submits that the victim has already been examined
on perusal
examined and he wants to place on record the testimony of a victim and the parents of the victim release the matter next week yes place it
my lord that
place it I'll grant bail why unnecessary let us complete the formalities
my lord
because the girl has in 164 he has said in see, I'll read it. If something is there, I'll try to help you.
Yes, I will produce the evidence copy of the victim.
Please file it so that we'll find out.
Fix up a date.
Find out ways. Yes. Find out ways how to.
No, that my lord, the case of consent, both are fled away.
I know this happened.
Thereafter,
I saw the age also. Don't worry.
Thereafter, my lord, I am in custody more than 1 year.
Yes, so
Sufficiently
get
because-
these evidence.
Oh, yes.
Okay, next.
May I please, your lordship? Here is the petitioner is a 20, allowed to the 16-year girl. And
Your
16
age
years,
is?
21. I'm
21.
reading in +2. But 164 I have annexed.
Yes.
She doesn't, the victim doesn't support the prosecution case. That
Yes, sir.
she has law of offense.
My instruction is that, my lord, today morning I contact the IO, my lord. He stated that since my 373 is there, my lord, plus 3. For that, I contact the IO stated that the victim appear, my lord, in the coordinated bench, my lord, on last occasion, my lord. She has stated before the court that the bail should not be given to the.
No, that is not correct. My lord, I was there and through video conferencing, she appeared and made a statement that I have no objection. And of course, the court adjourned this matter because IO brought the girl. Your lordship, kindly see the victim statement under 164. I am a +2 student, my lord. I am in custody since January. Again, ठीक है. Absolutely.
No, nothing is coming on record. Rather, on 1/8/2024, there is an order for the victim to appear.
A victim had appeared on the last occasion before my lord.
The coordinate bench appeared in coordinate bench. The IO, my lord, today morning I contacted the IO. IO stated that she stated before the court that bail should not be granted to the.
See, because this order is staring at the face of this thing. What I'll say is, a person to the order dated 1/8/2024. Again, let them appear.
My lord, I pay for an interim bail, my lord, because my attendance in the +2 gets, my lord.
I will take up
tomorrow.
Next, can you ask him?
Because he is appearing
Friday.
My difficult, my lord, she is particular IO. Because I am a religion.
I could have released you on bail. The problem is the order of a coordinate bench.
Let it be Thursday.
Coordinate bench says that let her appear.
Let her appear on Thursday, not Friday.
Thursday.
So Friday I'll have some.
Thursday, right now. A person to the order dated 1/8/2024. Mr. Misal and counsel for the petitioner submits that persons to the order dated 1/8/2024. The victim had appeared through VC along with the IO of the case, and she had no objection for granting bail to the petitioner. How Mr. Ragada then for the state submits that the IO he has received instruction. IIC he has received instruction from IIC, which police station? Nimapada police station. And he has who has said that the girl is not agreeable for the proposition of granting the petitioner to bail. Since there is already an order by the coordinate bench, it is appropriate that IIC/IO of the concerned police station shall appear before the court through virtual mode along with the on the next date appearing, please, on Friday. Yes.
All right.
60. Thursday, man. Okay.
Friday.
Right.
Yes, sir.
61 minutes.
60?
Free copy.
Free copy, yeah. 60. Akash.
I'm for the opposite party.
Yes. Are you appearing? No, 60.
60 file may not given.
None appears for the petitioner. Leaves the matter after 1 week. Yes.
61.
May I please, lords?
Yes.
My lord, the petitioners are here the parents, my lords. The son and daughter-in-law, my lords, have lodged an FIR against them, my lord. I am filing for questioning of cognizance and proceeding, my lords. My lord, may kindly have a glance.
This is a bail or questioning?
Questioning, my lords.
Okay.
My lords, may kindly have a glance at
bail over, huh? Okay.
At page number 30, my lords. The opinion given by the Family Welfare Committee, my lords.
You are Devraj Behra, 73 years. You are the father-in-law, mother-in-law.
Father-in-law, mother-in-law, my lords. Now I am
What
70.
is the FIR?
FIR, my lord, 498 and 323 allegation.
Notice is there, my lord.
Notice in addition issued to the
Notice has to be there, has to go to.
My lord, they are staying at abroad, my lords. My lords,
When you have to let them appear through VC.
my lords, we are unaware of the address of that them, my lords, the opposite parties, my lord.
What can I do? How can I in the absentia?
My lord, they are not appearing in the court also, my lord, trial court and so, my
Let
lords.
us see. Not appearing.
No, my lords.
Oh, then you will be acquitted.
My lords, these are old parents, my lord. Another son is staying abroad. They are unable to go, my lords, because visa and other things they are not approving, my lords, because this case is pending. And no allegation is there because page number 31. They have given a report that all these allegations are false, my lords. The family welfare report.
Let us see.
The committee, after having several rounds.
Where are you reading?
Page number 30, my lords.
30. Oh.
Yes.
What is this? What is this report?
The family welfare committee report, my lords. Once an FIR is registered, my lords, this committee, my lords, goes through the FIR and there are meetings conducted, and thereafter his opinion is given to the court, my lords. In that opinion, they have said that the committee, after several rounds of meetings and discussions, come across various evidence, out of which some audio recordings were also presented before the committee. After listening to it, the committee found that there is a conflict between the parties, husband and wife one side, and in-laws due to property of in-laws. The allegation of dowry demand is false. Even the allegation with respect to the custody of the ornaments.
Who are the member of the committee?
Members
of the committee?
Members of the committee, my lords, there is civic body, my lords. The page number 31, it's given, my lord.
Right. You tell me the designation. What is the relevancy of this committee report? Can it supersede the 173 report?
It's in Rajesh Kumar.
If that is the case, then every charge sheet will be quashed on the basis of committee report.
Well, these allegations are.
They are neither investigating agency nor the adjudicating authority.
My lords, in Rajesh Kumar Sharma versus State of UP, this Honorable Supreme Court directed to form a committee. My lords.
This was done when? Is it a part of the charge sheet?
Yes, my
This
lord.
committee report.
Yes, my lord.
Yes, Mr.
No, my lord, I have not really received the copy, my lord. Take instruction, my lord. And they get there everything. my lord, then-
Where is the husband?
My
Your
lords,
son?
he is also with the wife, my lords. Yes, my lord.
The problem is both of them have fought here, and they went to America, wherever. And these poor parents are unnecessarily got stuck in this matter. Let them fight it out wherever they want to fight.
I'll call for the entire case record, my lord, CD and everything, my lord.
I'll put it. You tell me. I'll pass it.
My lord, next week.
See there. See these old parents. Why should they suffer?
1 week after, my lord, so that he will apply copy.
Monday.
My lords.
Monday. Immediately on the Monday. 27.
My lord.
27. You
My
just see.
my lord.
I'll pass it because see the husband and wife, there was some problem. See, wife lodged an FIR against the husband and the mother-in-law, father-in-law. And after lodging FIR, she went to America. The boys also went to America. And these people are stuck with this case.
Suffering there.
She is not appearing also. Give the entire paper book and so that, yes. 62.
2 million. There is a defect, one defect number 18.
What is that defect?
Before I don't know.
Oh, forget certificate copy in
Yes, but the transfer brief
electronic days. What certificate copy? You argue. And you are ready or not?
is a transfer brief. You will see my
Okay. Then urgent, simply urgent.
my Monday you will see next month.
He'll give it.
Yes.
63 and 64 minutes withdraw.
Withdraw. 63, 64 withdraw. Yes.
65.
Infectious. During infectious withdrawal, dispose of program. Yes.
67.
In last occasion, your lordship was directed to present both the parties before the honorable court, my lord.
Yes, are they?
My lord, it's a matter of a compromise. The opposite party number 2, the an affidavit being shown before
That's
the.
right, but they have to be there, sir, because the allegations are that.
She is not coming. The file an affidavit before the oath commissioner. But she is not
No,
coming.
not oath commissioner. Only on VC also at least she has to come.
In this connection, your
If
lordship
the
first.
oath commissioner and notary public will decide the cases, then
Yeah,
why
yeah,
should
yes,
the
ma'am.
High Court?
My lord, I am not saying that. She may be noticed so that she will appear.
I
Last,
issue notice, no, it's all right. Issue notice to opposite party.
but number 2.
Opposite, returnable within a week, huh? File requisites. Verify and quash it, no problem.
Obliged, ma'am.
Yes.
68.
Kindly the Woodland Council for the petition submits that they have settled the case to issue notice to. Yes.
68.
68. Yes, sir. Passing.
It's a matter of a disposal matter, my lord. Earlier in this case, the honorable judge has been, honorable court has been pleased to direct a order. Your lordship may kindly have a seen the order para 5, my lord, earlier order, my lord. And this petitioner did not comply it, again filed.
Para 5, which order?
Earlier order, my lord. I am sending to your lordship.
Same. Para 5, huh?
In anticipatory. Four 406 420, my lord.
$13 lakhs in 5 installments.
Yes, ma'am.
Quashing, who is appealing? You are appealing.
I'm for the petitioner.
What is this going on?
Well, I prefer next week.
No, next week. See, you have approached this is, you approached, you got an order that you will pay 13 lakhs in 5 installment. You moved an application, then it was made 14 installment, 16 installment. Thereafter, you did not pay that money. You approached this court for quashing of cognizance order. And this order, this court coordinate bench has given a very disturbing remark saying that, see, you have been forum shopping and all. Thereafter, again you file another petition. What is this?
The petitioner is ready to pay the remaining amount.
Ready to pay. Who stops you? But how can you ask for quashing again? 8/7/2022. Same order, 8/7/22. How can you pass like, how can you file this petition like this?
Let them materialize before the court below and then come to the.
Will you withdraw or I'll impose cost?
Next week, my lord.
No, just now. You can't use the court like this. Repeatedly keep on coming every day, moving application. Better that you withdraw to avail the law. So that at least the protections are there, you get it. Right out. And counsel for the petitioner seeks to withdraw the petition to avail the remedy under law, or with this liberty the petition is disposed of. Why to invite adverse order? Already orders are there. You go. Yes.
69.
69, my lord, there is a defect. I have been permitted to remove the defect in this.
11, 15 and 22. What are these defects?
Page 11 to 16.
Are you serious about this petition? If you are serious, you would have done it. What is this matter is about?
Matter, my lord,
Year back you filed it.
my lord, addition of offense.
326 and 307, my lord. Then thereafter, earlier he was granted the bail, but adding the higher offences, then he is coming to this court and file. He has filed.
Passing.
No, my lord. Bail, my lord.
Bail you will get it. That Agrawal judgment.
Sushila Agrawala, judgment of Sushila Agrawala. It is clear that in case of addition of other higher.
You go and do it. Who stops it?
But though there is a higher offences.
Therefore, you Sushila Agrawal.
My lord.
In the other offences, the FIR was registered under which offense?
147, 148, 354.
What are the added now? Added offences?
307 and 326.
All right. Petitioner is in this petition is seeking quashing of the entire proceeding. Entire proceeding?
Proceeding, my lord, your lordship may not.
What are you asking in this?
Bail, my lord.
Granted for bail, my lord.
Bail in the 482, what? What is this?
It is not.
File proper petition so that I can give you relief. See the prayer.
My lord.
You ask for quashing so that I'll add that Sushila Agrawal and give you relief. Withdraw it, file it properly. Then counsel for the petitioner seeks to withdraw this petition to file a proper petition. Let him do so within a week. Dispose of. You file a fresh one.
My lord, certified copy may be returned.
A certified copy filed in this petition may be returned to, shall be returned to the petitioner, replacing by the photocopy. File a 482 petition, tell all these things, so that I will give you get it. That was the only defect. That is defect.
Miller.
Yes.
Item 95, Miller. Petitioner counsel also is there, Miller.
You want?
Milord, it's actually a voluminous document.
Oh, it's all right. Adjournment. Adjournment. Okay.
Milord, your fix any date.
He will give a date. Don't worry. Okay. Item
70. May I please, Lord? My lord, questioning of the affair on the ground that, my lord, this present petitioner who are before the principal accused. Rather, they are the friend and relative.
Investigation is on.
Investigation is on. No. My lord, kind of a glance, my lord. In the meantime, my lord, the principal accused marriage to the victim and they blessed with the sum. I have annexed.
Go and tell that to the police.
My lord, only my lord, I pray before your lordship, fix up a date in which date I will appear both the victim.
No, what I'll say is whatever has happened meanwhile, you go and tell to the police. Police will take care of it and file a closure report.
On that observation, my
yes, I'll observe that.
Again.
What are the offences?
Offences, my lord,
363.
Again, 363, 34. FIR was registered. Thereafter,
you are the.
I am the friend.
Right. Petitioner in this petition, the petitioner is seeking quashing of the FIR registered against him, along with the
principal accused.
The allegation against the petitioner is that he has helped the principal accused for
kidnapping the
victim girl.
Which is the opposite party number 2.
Opposite party number 2. Then counsel for the petitioner submits that now the petitioner, the principal the victim.
And they have also blessed with the son.
They are also blessed with a girl child.
Male child.
Male child. The investigation in the present case is going on. The petitioner is at liberty to inform all these development to the investigating officer in the case. If such developments are informed to the investigating officer, the IO shall verify the same, and by taking into consideration this aspect, may take into consideration this aspect for the purpose of may consider right. You have to file 173. Okay, he'll take consideration.
Thereafter, my lord, he will take necessary step.
I can't tell the police that you should file charge sheet or you should not file charge sheet because this is not. I have indicated that
yes,
you are married. The principal accused is married. Why do you worry? Are you on bail?
Oh, my lord, that instruction.
You tell me, I'll protect you.
Yes, my lord, protect me.
Because see, in this case,
yes, my lord.
this is a harsh case. His friend got involved with some girls and he has helped him. In view of the peculiar facts of the case, no course of action shall be taken against the police, against the petitioner.
Petitioners.
Yes. Subject to the petitioners appearing before the IO and informing, bringing on record the aforementioned development. You go and tell
both that the victim will appear and this present.
Yes, do whatever you want.
71.
Yes. What is this? DB case.
My lord, also copy notes are my lord in this case.
No, this is notice has been issued. Issue notice to the opposite party number 2. This is a matrimonial dispute.
Yes, my lord.
Issue notice to the opposite party number 2, returnable within 2 weeks. Okay.
72.
Yes.
I am a teacher, my lord. Seeking for the questioning of the FIR, my lord.
I'll take it up at 2 o'clock. Okay.
Borchana pays 134 2005 and Borchana pays 135 to 2005. So far as the 134 35 is that has been disposed of by Honorable Chief Justice and in view of the compromise between the parties. Now this matter has also been compromised between the parties.
The order. Show me the order by which.
Yes, my.
What are the offenses?
The case has been disposed of, that is under 395. See?
No, I am talking about this case.
This case 307.
307, 506, 341.
307, where is the victim?
My lord, kindly see the prayer, my lord. What is his prayer, my lord? Cognizance. Cognizance order 11/1/2011.
That is why the.
My lord, kindly see the page 11, my lord.
Yes.
Page 11, 11/1/2011. That order he has challenged. Middle portion, my lord, kindly see. Hence, the charge is framed thereunder in writing by separate.
I understand it.
So, charge was framed. So, he has challenged that cognizance. So, this prayer, my lord, either he may renew his prayer or.
Now, what he says is he has settled the dispute. How many cases were there?
There are 2 cases in this accused person. In other cases, I am for the informant. In that case, has been compromised.
Where is the informant? You call the informant because see, what is the stage of the trial now?
Yes, that is.
Stage of the trial.
Trial only IO and doctor has to be examined.
We want this court to interfere at the fake end of the trial.
Yes.
Only on the basis that one of the
they are not coming.
What was this case which you find?
That is 395.
395.
Yes.
Here there is 307. Victim. Where is victim? Have you implemented victim?
Yes. My lord.
Where is he?
My lord is appearing for opinion 2.
You have any objection? No.
No.
Where is he? Call him. What are the injuries? These are not compoundable offenses, sir. You have to bring him. What is the injuries?
He has not annexed any document. He has not annexed any document. Challenge the cognizance, but actually it is charged. Then, my lord, another thing is your lordship may.
Proper petition also you have not filed. That's the problem.
Other cases are not comparable to 395, my lord.
That's right, but what is the injury received? At least injury has to be seen. 307. You are not bringing the
Any
victim also to the
Then-
court.
My lord, that will be adjourned, I will file.
Tomorrow, day after.
My lord, may I pray, my lord, one thing? That your lordship may call for a report from the court below that what is the status of the trial.
Why to travel?
If it was, my lord, if the trial has already been completed, because 2011 charge was framed. What is the status of this
In
case?
view of the compromise between the parties, in that
Nay,
case, I am for the
compromise
infirm-
doesn't mean 302 also you murder someone compromise.
In that case, I am for the infirm. I have filed affidavit.
That's a different story.
In
But
this case, they
you file an affidavit
Yes.
stating the stage of the trial,
Right.
status, and bring the
injury
victim.
report.
Bring the victim. Next week or this. Yes.
So, my some time may be granted to go get the certificate.
Next week. Certificate copy is not required. You just give the affidavit. No. 107. 107 may not be taken. Final hearing.
Up to 111 you can take it. 111 you will most of them are orders. 107.
Senior counsel is there. Senior counsel is there. What is this matter?
Matter, a vehicle was seized on the allegation of carrying liquor without permit.
457.
Eh?
457.
457, the order was passed, but that was not complied the seizing officer on the plea that the vehicle was sent for confiscation to the authorized officer. And on the other day, your lordship was pleased to call for the report from the authorized officer. That record was available. I am.
Is the report is there?
State my lord.
Report is there?
My lord, report is there.
What is the report?
Report my lord. Paragraph 7 my lord. It is mentioned that 145/8/2023 Learned Court of authorized officer comes Superintendent of Excise conduct pass an expiry order for confiscation of the seized procure along with the article with the direction to the IO take necessary steps for auction sale.
You have to challenge that order.
I'm just coming to that. That is the crux of the matter. What happened? On the same day, two orders were passed. One is releasing the vehicle pending trial or confiscation proceeding. On the same day, the authorized officer passed the order. And if your lordship go through that order without service of notice, the order was passed. The law says that the court must satisfy that a notice it will properly serve on the
Those things can be argued in that matter, not here.
Nay, why I am submitting so, till yet I am not aware because the record is here. I cannot obtain the certified copy, that is the appealable order. Am I clear, my lord?
Yes.
Unless I get that order, I cannot prefer appeal. That is the question. Second question is, there are two authorities. One is a authority which is quasi-judicial.
What I can best do is, I'll adjourn it, you file another petition challenging that, get it tagged with this. That's the only way both the things can be taken care of. I'll simply adjourn pursuant to the order dated, where is that order? Which order the court has asked?
24/4/2024.
24?
24/4/2024. Okay, order. This one will order. This one will put my lord. This one will put my lord on. 16/2/2024, another order passed by this one for my lord.
In pursuant to the order dated 16/1/2024, Mr. Ragada has placed on record. 16? 16/1/2024 and 16/2. Do the order.
Another 24.
And no, understood. Pursuant to the order dated 16/1/2024 and 16/2/2024, Mr. Ragada has placed on record the instruction he has received from
from the IIC Chowdhury PS.
IIC Chowdhury PS.
Paragraph 7.
Who inter alia report dated 5/2/2024 has stated that on 7/8/2000
Paragraph 7, my lord.
Para 7, huh?
7.
On 25/8/2023. The authorized officer come the superintendent excise Cuttack has passed an ex parte order for confiscation of the seized Scorpio along with other articles with a direction to the IO to take necessary steps for auction sale of the vehicle and other articles. In view of the fact that confiscation order has already been passed by the competent authority, Mr. Mahapatra permits that he would be challenging the said order in a separate proceeding. Hence, he seeks an adjournment. We see matter after 3 weeks. Meanwhile, liberty is granted to the petitioner to assail the order dated 25/8/2024. Weeks after 3 weeks. After 3 weeks of listing it, you challenge that and get it tagged with that. Yes.
Just a minute. Because that order itself is applicable as I understood. Either I have to file an appeal challenging that order and intimating this court that the appeal has been filed, or I will file directly a petition to consider both the order.
You are the best person to take the call. I am not here to advise. You know what to do. You know better than anyone else present in the courtroom now. Yes. Next.
ମୁଁ ସେଇଟାକୁ intimation ଦେବି in form of
you know
before going to leaving the court, I will say, in my personal view, I am not aspiring anything. After the enactment of Constitution and the fundamental rights, the executive authorities, time and again, they are ignoring the fundamental rights incorporated in the Constitution itself, and they are acting. All the agencies exercising power, executive power, they are acting as if while you were ruled by the British.
Actually, in these kind of cases, what happens is if you file a 457 application, the accused person thinks that I have pursued better remedy, I will not go and appear there. Confiscation proceeding goes ex parte.
457 petition allow higala.
That is the reason, despite knowing that confiscation proceeding is going on, the accused might not have gone there. The petitioner might not have gone there. That is the reality. That's the reality. And suffers an ex parte order. He says that I have an order, why should I participate there? He didn't go. Yes.
22.
Yes.
Well, I am the teacher, my lord, working as a teacher, my lord. Due to some dispute occurred between the headmaster and me, the present FR is lost, my lord. That dispute is I have avoided in my...
But the investigation is still going on, sir.
Well, where is the FIR first? Where is the formal FIR? Page 12 only that what
Complaint
offences
whether
was
FIR
made.
is there or not, nobody
Yes,
knows.
FIR there.
Where is that? Where is that? You research that also you don't have.
Receive the report as it reveals a organization 341/323.
But where is 154 format?
Perhaps there is a... Therefore, it is...
Withdraw it, wait till the investigation is over. I know. Then the counsel for the petitioner seeks to withdraw the present petition to revive his prayer for quashing of the proceeding after the charge sheet is filed, if cause of action still survives. All right. With this observation, the petition is yes.
There are defects. I'll remove it. Kindly adjourn to next.
What are the defects, sir?
Number 6, 11, and 13. Index error.
Neat copies to be filed. By the way, what is this petition? Cognizance order. 22 cognizance.
My lord, he has not solved the copy, but in 73, 74.
No, 1cc case.
My lord, in 72, 70, 73, 74. Same accused person from the same PS.
No, this is
This is my lord Sambalpur PS, Cyber PS 7/21.
How many cases do you have today?
My lord, in fact, there are, this is a proceeding under 138 NI Act, and the complainant has taken so many checks. Complainant has taken so many checks, and one after another, he has presented.
Complainant has not taken. You have given. There is a difference. You have given. Complainant has taken means by force has he taken.
My lord, in this respect, he has also lodged an FIR. Forcefully, he has taken.
What happened to those FIR?
Kindly next.
See, these matters are unnecessary pending. How many matters are there? 3.
My lord, 2 matters. Another matter is there. CRLMC number 5481.
All the matters are
81/23. That was not listed.
Least on a particular day. All the matters. Give the numbers. All the matters.
My lord, another is CRLMC 5481 of 23.
Along with this.
Along with these 2 matters.
2 matters. Please. After 1 week. Yes.
75.
Question of FIR.
FIR. Investigation is on.
My lord, they assaulted a lady forester. Anticipatory bail, it was disposed of, but the order was not uploaded, but it was disposed of on 23/11/23.
Investigation is on.
23 matter, I have no instruction.
Huh?
I have no instruction whether investigation is going on or not.
Non-APS for the petitioner in the interest of justice adjourned 2, 3. Withdraw. 75 withdraw already.
75 withdraw.
Yes.
76.
My lord, on behalf of Sambit Samal, kindly adjourn for 2 weeks.
No, what is this case?
CRP.
Sierra Leone, I know, but what are you asking?
For adjournment for 2 weeks.
Quashing of FIR. FIR quashing 2020 FIR. What happened to the charge sheet?
406, 468.
Charge sheet filed.
Charge sheet, my lord, arising out of a complaint case. Whether charge sheet was submitted or not, it was not annexed in. Only
Yes, charge sheet has been filed. Huh?
No instruction is there.
You have to tell me. These petitions are not routine petition. You do 1 year back you filed the petition. You don't know, huh? Defects are there. You have not cured the defects. One day I am giving you to cure defects. Only one day. Because I think you are not interested to do this matter. Only for the sake of filing, you are filing. 2 days, thanks for curing the defect. Otherwise, without reference to the court dismiss. If it's cured, after the yes.
77.
May I please? This is a peculiar case where initially affair was lodged by the opposite part number 2. After due investigation by the investigating agency, submitted the final report. Prior to coming to this case, your lordship straight come to page 18 of my brief. Towards last
18, huh?
18 of my brief. That is the charge sheet column, and what is the opinion? In this case, there is no item of evidence against both the FIR named accused persons, namely Vasudev Pradhan and Gautam Pradhan of village so. The complaint Rasmita Pradhan, her godly uncle Banambar Naik, godly aunt Srimati Bedi Naik, who are interested witnesses in this case, and Julie and Ratikanta Raut have cogently lost this false case. The complaint Rasmita Pradhan, which is they are liable to be prosecuted under section 211 of IPC. Against that is the opinion of the investigating agency. that a false and malicious proceeding has been initiated against a old and infirm person.
Yes.
And for that reason,
thereafter protest petition.
I am coming to this case.
Yes.
That protest petition has been filed.
Have you checked what are the difference between protest petition and same exactly?
Well, protest petition cognizance was taken.
I know that, but protest petition, what are the allegation in the protest petition? What are the allegation in the file?
My lord,
Well, protest petition he has not annexed. Only order that the order.
So where is the protest petition?
Protest petition he has not annexed 202.
You
That
say
statement was not given.
My lord.
Unless you give that, how will I?
No, my lord, I am submitting.
Because see, the police says that
There is no evidence.
That's the complainant. Again, the informant, my lord.
Informant. Must
They
be
have
very
not-
serious.
My lord.
And if she repeats the same thing in protest petition and cognizance is taken,
My lord, my
it
lord.
is very serious.
Your lordship is correct. What the law and code below says so?
Where is
Using
it? Show me the protest
No,
petition.
protest petition se kon kala se lekhile. Oral statement, in this case, statement of the recorded under section 161 CRPC, statement under section 164 took the cognizance. While he has accepted that prima facie case is not there, drop the proceeding, issued notice to the incompliant. Where is the question of the to taking note of this case?
Place that on record. How will I get it?
नहीं से कौन कल की इन्वेस्टिगेशन है जाए ताकू नहीं गल ताकू ड्रॉप कर देले प्रोसीडिंग दे हैव द इन्वेस्टिगेट द लॉ एंड कोड बिलो ड्रॉप द प्रोसीडिंग इन while the investigation has been started the court has to accept two things. It has to submit two things, that is one is final form, second is final report. If final report has been submitted, the court has two options, whether he has to proceed with the case or to drop the proceeding.
Those are fundamental. Don't.
Once you have accepted the final report, what is the question of the law and code below encouraging
that is that precludes to file protest petition?
No, protest petition filing kar paribo. There is no scope.
Show me the protest petition. That's what I'm saying.
Say 161, 164 को देखिए cognizance नहीं गले.
My lord, it was also written that in 202. That statement.
These are fundamental things. You need not waste time on this.
My lord.
At least at the 3:30, I need not be told about 202 and 202 and all. Show me the protest petition and statement under 202. I'll have to compare that with the initial FIR 164 statement. If they're exactly the same, then you have a case. I'll quash it. Simple.
Next week. Next
because
week.
the police says that she's unnecessary and
she's liable under section 211 of IPC.
211 also.
IPC.
So it is a serious matter. So show me. Those two things have to be filed. Mr. Das and counsel for the petitioner seeks 1 week time to place on record the copy of the complaint of the protest petition as well as the statements recorded under section 202 in support of the complaint of the protest petition. Release the matter on.
Next week in specific date.
Specific date. So yes.
Definitely for submission of trial court order. Today already we filed the trial court order. Matter next week.
October. Here.
79.
Yes.
This is a case where the informant petitioner is the in-laws. The offense is 498A along with other offenses. Your lordship knows that how a case has been instituted against the in-laws. General and cryptic allegation, they have been probed in the instances. Even though the major part of the occurrence had been taken place within the territory of Hon'Ble, they have initiated the proceeding at Barampur. So my humble submission before your lordship, there is lots of...
Charge sheet filed.
My lord, I am challenging the...
Show me the charge sheet. What are the allegations against Bonoja? What is it?
Independent petition, page 16.
Bonojini, sir. Show me the charge sheet.
Charge sheet, my lord. That is page 31, my lord.
Anything is there against Bonojini?
General allegations.
This case was supervised by DSP so-and-so, Barampur locally. As per his opinion, it is a true case under section 498, 34, so-and-so against accused husband.
Bishop Sankar.
Sir, Mother-in-law, Banojit Mishra,
and sister-in-law,
Vishwa
Vishwa Bharati, Dhundu Vishwa.
There is no evidence under 506 against the accused person, and also could not found any evidence in the against fire so and so, Bhaskar, sir, so. Bhaskar, all other family members were exonerated except the husband and mother-in-law.
Mother-in-law, sister-in-law, married sister-in-law who has got married since prior to the marriage of the.
So these are the evidences.
This is the evidence. My humble submission before your lordship, you will come across the judgment of the apex court, Priti Gupta, and another is that is many judgments are there. It should not be encouraged because nowadays that has been floating in such a way that 498A.
You simply don't tell me the general law. You simply tell me what are the offences against you. Otherwise, you have to go and argue on charge.
No, charge, your lordship. A mother-in-law who is an old man. She is an old man, my lord. 74 years old.
Bring the informant.
My lord. Informant as opposite part number 2.
Issue notice to opposite party, returnable after 1 week. Yes.
Can I pray?
I know what you will pray. I am not inclined. I will not give stay. I know. Once stay is given, after my retirement, this matter will come.
Cannot be.
So no, I'll dispose it up. I know I have seen the age of the women. He is 74 years
74 years.
And see mother-in-law.
Mother-in-law.
And if there is a fight between wife and husband, let them suffer. Why should the mother-in-law suffer? So therefore, I am giving it. I'll quash it. Bring her, I'll quash it. Here.
My lord.
Item 80.
It has to go to another bench. No. This so far as the co-accused person is concerned, yes, the other bench has granted bail. Subject to yes.
81.
Withdraw.
82.
I pray for an adjournment, Your Lordship.
Why?
Your Lordship, I am not the conducting counsel. Senior has to come and argue the matter. My senior has to.
So senior, you tell me what are the facts.
So we have challenged the proceeding initiated as GR case number 755 of 2005. Your Lordship, the present petitioners were added. The allegation against the present petitioners is that they have helped in protecting the accused person from not getting arrested, due to which the present FIR was lost by the officials.
Charge sheet has been filed. Huh?
Yes, Your Lordship.
Cognizance is taken?
Yes, Your Lordship.
Who is the complainant? I'll issue notice to the complainant. Okay. To the opposite party number 2, returnable after 2 weeks. Yes.
Obliged, Lordship.
83.
83 may I plead, Your Lordship. The petitioner before Your Lordship for quashing of the total proceeding, as the case has been charge sheeted against the petitioner for the alleged offence under section 306 and 506 of IPC, Your Lordship, on the allegation that I may go through the FIR, Your Lordship, on running page 10, Your Lordship, but the allegation against this petitioner, may I 7 line before, Your Lordship, in last of the FIR, total of the FIR I am going to जाउछि कि मो झियो कुमारी पायल जेना 17 years.
Come to the charge sheet.
Yes, Your Lordship. On the charge sheet that the offence is 306 and 506 of IPC, Your Lordship, against this petitioner. On the charge sheet, the statement, basing upon the statement of the informant and his wife, the victim mother, that the case has been charge sheeted. No other
Not necessary.
corroborating
evidence in the conviction stage you have to see.
NBW has been issued.
You tell me that.
that I have annexed. That I have annexed.
Where is the NBW?
Yes, your lordship, running page 40, your lordship.
40. Come to the point, unless
Yes,
you prayer
yes,
everything
my
like that.
6-12-23.
Right.
Basing on the
When you appear, huh?
I will appear and let me release.
Not release on bail. You have to
that
whatever-
because why I am saying, your lordship, no such corroborating evidence regarding the photo. What the allegation?
you have to your bail application rejected.
Yes, I am bound down.
You might have argued all these things.
Doubt
about it. If on the basis
Yes,
of which
on
you
the-
could
on
not
the
get the
page-
bail, you
on
think
the-
that it will be quashed.
On the face of the record, that is there.
When are you
that-
going to appear? I'll stay the order of NBW, go and appear.
Yeah.
And resort to the remedy. Till then, no force will. Okay?
Yes.
Let him appear. Right up. Although the petitioner had challenged the entire criminal prosecution initiated against him, however, he confines his submission, challenging the order dated 6/12/2023, whereby NBW has been issued against him for his non-appearance in the court below. By the order dated next order, by the order dated 6/12/2023, the JMFC Dhamnagar.
Yes, ma'am.
Dhamnagar has issued non-bailable warrant against the present petitioner in GR case number 506 of 2022. The constitutional petitioner submits that he claimed to be appearing before the court when of 15th of September.
Yes, we can.
15th of September, on or before 15th September, and resort to the remedy available to him under law. Regarding head to the statement made by the counsel and the facts of the case, the execution of execution of the warrant dated warrant issued then JMFC by order dated 6/12/2023.
6/12/23.
Shall be kept in remains, subject to the condition that the citizen shall appear in the court below and resort to the remedy available to him under law. Until then, no course shall be taken. Yes. Next.
Obliged.
The sister-in-law of the informant, my lord. And
the petitioner, citizens shall not be allowed to seek further extension. So, extension for citizens are allowed to seek extension. Extension for appearance before the court.
petitioner is the married sister-in-law of the informant and is a government employee, my lord. My lord, initially the FIR was registered under section 498 13 376.
Married sister-in-law.
Married sister-in-law. Married actually is under section 498 326.
Next.
My lord, I am from Bhavani Patna. I am from Bhavani Patna, Sankur, my lord. I am filing a question of the FIR. I filed FIR on. I also filed FIR. My FIR was not lost, and taking advantage of that, they have filed a FIR which was lost. Charge sheet has been also filed.
Charge sheet has already been submitted. You have to challenge cognizance or proceeding. You withdraw it and file appropriate proof.
My lord.
When charge sheet was filed?
Charge sheet filed
1/9/2023.
my lord. In spite of child, they have annexed the my lord, the charge sheet, my lord. But in fact, their prayer was the FIR. How can my lord
What are the ground for quashing?
Ground is my FIR was not lost, my lord.
That doesn't mean that this will be quashed.
They have lost the FIR.
What your case is, you filed a cross case. Your case is not registered. That doesn't mean that this FIR will be passed. After investigation, charge sheet has already been filed. You have a remedy insofar as your grievance is concerned for non-registration of FIR. You have a separate remedy.
Correct.
But that can't be a ground for quashing of this proceeding.
They are not in their section 354. I have lost, but they have given 353. He is not a government servant.
Sir, all these things, sir, at the stage of framing of charge, you can argue.
My lord.
Right on. And counsel for the petitioner seeks to withdraw this petition to argue all the points at the stage of framing of charges with this liberty.
Lordship, I will be permitted to withdraw.
Withdraw. Yes.
Question of ordinance.
Order dated
24/5/16.
16, no.
Yes, sir.
87, na?
Prayer. No, 18. It's not that withdrawal.
87 withdraw, right? 86. 87.
87. Copy not, sir.
Cognizance order is 19/1/2023.
Copy not, sir.
The file petition don't come to the court. Defects are there. Defects are there only. How many days? 2 days. 2 days. Dismiss without reference to court. 2 working days.
88.
No. In this case,
Passing of cognizance dated 24/5/2016.
case and counter case. On the basis of compromise, in the counter case, all the accused have been acquitted. I have annexed 4. In this case, I am the petitioners who have filed lost the FIR. In our FIR, they have been acquitted on the basis of compromise.
What is the offense here?
Second is there in both cases.
What was the offense there which was passed? You were accused in
yes,
you were the informant in that case.
In that case, I am the informant.
What was the offense there?
Offense, my lord. 324, 307 is there. 307 both the cases.
Both the cases.
506.
Where are they? Have you called them? The victim.
People also pass order.
Why should I pass order? You have settled the issue, you bring them.
Also, I put up many date and on that date, I will.
Says that there were 2 FIR insofar as the FIR in which the petitioner was the informant.
Yes.
That has already been passed on the basis of the settlement, and this matter is also to be passed on the same ground. He seeks an adjournment to ensure the presence of opposite party number 2 on the next data hearing, and accused also of being all as well as opposite party number 2 and the petition next data after 1 year. Yes.
89.
Personal question.
Withdraw. 89.
Lots of date.
Date.
Problem.
90.
Lordship, in the second item, Mr. B. Sahu is pursuing the matter. Lordship, he is suffering from fever. Substitution on the previous occasion, substitution was there, Lordship, and we have already filed the considered question.
Simply urgent.
Obliged.
91.
Please, your Lordship. In the last order, I have already submitted 4 sets of paper proof.
I humbly pray it will be accepted.
At 4 o'clock, I'm just adjourning.
On Thursday, my lord. On Thursday, this Thursday.
Why so urgent? Bail rejected.
My lord.
Bail already rejected.
Friday as well.
Friday.
97.
May I please correct? A poor driver in block development office. In super cyclone 1999, entire house has been demolished due to the super cyclone. Nowhere. At that time, a scheme was floated on behalf of the government, that is Indira Awas Yojana. He is illiterate. Somehow or other, he has applied for the Indira Awas Yojana, and accordingly, 22,000 has been given to the. I am a driver. In that time, I was a driver. The BD block development office. 22,000 has been allotted in name of the present petitioner. Accordingly, he has constructed the building. And thereafter, in the year, my lord, that is 2010, that case has been initiated on behalf of the Vigilance Department.
Where is the charge sheet you show me?
That is charge sheet, my lord. I have already deposited the entire amount which I had, the amount which has been allotted in favor of the present petitioner, that is 22,000.
Yes, yes, Mr. Marana.
The number of beneficiaries in connivance with the public servant, they have misappropriated the money meant for that Indira Awas Yojana. And he is not eligible for that one. He is a public servant. He is not entitled. When the investigation is taken up, he returned the money. It's an admitted case of misappropriation.
Where is the charge sheet show me?
Charge sheet.
Charge sheet is
You knew that you are not entitled. Why have you?
No, I am a poor driver, my lord. To that extent, I have considered that I have.
That is the return of your money itself creates a problem for you.
My lord, I have applied for before the authority concerned. Authority, they have applied their mind. They have sanctioned the 22,000. Only 22,000. I have constructed a building because due to the super cyclone.
Money is not important. Crime is important.
That means, my lord, I do not know.
You must be in connivance with the other senior officer.
No, my lord, no, my lord.
And
for
senior
that
officer,
reason,
you might have paid
showing some bona fideness, I have already deposited the entire amount. Poor driver.
In a crime, crime, what is the bona fide about it?
Because of.
See, you are the one of the parties for the misappropriation of Indira Awas Yojana.
No, not misappropriated.
You are one of the beneficiary. Being a government servant, you are not entitled to. You mix up with the senior officer. You might have given a percentage. 22,000 rupees you give me, I'll give you some money. All these, therefore, show me the charge sheet.
Yes,
you are challenging cognizance order, you don't have a charge sheet with you.
Charge sheet I will produce the next.
And the very fact that you said that you paid the money, that means you admitted your crime. Go and face it. That is not a positive point. That's a negative point.
Negative point. Even though, my lord, go driver, after knowing the same, he has deported.
These are PC. It is not ordinary cases.
No, they have not denied that I am not eligible. I will file the charge sheet before your lordship.
These are corruption cases.
No, corruption
cases. Obviously, these are corruption cases.
Indira Awas Yojana jaha kuch milala semane karle mo driver ta, poor driver. Where is the knowledge that a driver will? That is
I don't know you. For this crime, you might have been poor, but if you are doing all this business, then you must be.
No, driver ta nahi gala puni dei immediately after knowing the same that.
Dei the problem kurch.
Sit.
2002 ରେ ନେଲେ 15 ମାସରେ ଫେରେଇଲେ ଆଉ
2010 ରେ କଲେ 2010 after lapse of
sanction is not required.
Sanction
is required.
Sanction ଆସିଥିବ ମୁଁ ଜାଣିନି ତାର
check it up. You file the charge sheet, let him check up the sanction.
Mail.
Some departmental proceeding is also initiated.
No department proceeding has been initiated.
Let's check it up if, because he is in any case money only 22,000. You find out some way. Don't that emotional speech will not work. You have to tell me some material so that I can give indulgence. I have paid money means you have pleaded guilty.
Admitted.
Then go and face it. Instead of saying that, what are the points you from the charge sheet you point out so that
that is
there is no 120p or something of that sort, then if there is no 120p is not
attached, then I am not liable.
Then you show me those things.
Next week, any day, next week. Charge sheet along with the boss.
Yes, Mr. Das, Land Council seeks 1 week adjournment to file additional document. File additional document within 1 week.
So 4th rest.
Yes, 4th. Yes.
4th September.
Yes.
98.
Please, madam. Husband and wife dispute that has been settled, and wife has already received permanent alimony, and this is the only case about the criminal proceedings which I have come for question matters. And
he has taken permanent alimony and
they have received. Yes, judgment I have annexed. Judgment I have annexed.
And was there any settlement there?
Yes. Yeah, after settlement.
So in the settlement, whether she has said that criminal case also,
no.
I'm not.
Yes, that is not specific mention in.
So I'm issuing notice. I'm issuing notice.
Notice I was already issued. It's repeated after repeated notice. Special messenger was also issued, but she is not appearing. Yes, she has already married and gone from her in-laws house. Her parents through special messengers. Everything has go. He is not interested to contest or not.
There is a stay also.
Yes, sir. Yes.
Despite repeated notice to the opposite party number 2, public the informant. Opposite party number 2, na? No, opposite party.
Only opposite party. State is not a party here.
Opposite party. State, you have to make the party 498 fire. You make the party. You can't proceed with this washing business without state.
Without knowledge of the state. Yes.
You plead the state.
Copy the
But yeah, sorry. This is a court of record. You have to correct the record.
I copy already, sir. I may be permitted to add the state here itself also.
Informant, she has not appeared in this court. The petitioner has also not included the state as a party to this proceeding. It appears this matter is arising out of a matrimonial discord, where the petitioner number 1, who is the husband of opposite party number 1, has got separated by judicial process, and permanent alimony has also been paid.
Yes.
On that ground, the petitioner is seeking quasi. Since after repeated notice, the opposite party number 1 has not appeared. IIC, which case? IICPS?
Special messenger has already gone.
Regarding,
not a special messenger.
regarding the special messenger, sir, regarding the special messenger, my lord, there is no any information regarding.
1 minute, IIC, who is IIC? You tell me.
Kumbharpada PS.
Huh?
IIC case on the
Mahila PS.
Mahila PS.
IIC, sorry, IO of the present case in Mahila PS Bhubaneswar shall make a last endeavor to serve the opposite party number 1. Opposite party number. Release the matter after 2 weeks. Interim order to continue. Yes.
One submission, my lord. Special mission has already been issued from this honorable court, and the special mission had gone to their house. The father has already.
Today I pass.
No,
so therefore I pass the order. Next time you come, I'll pass it.
Oh, that's good.
Then in all the modes you have tried. I can write.
Yes.
I can write and pass it.
Yes.
Simple.
Yes. I may permitted to.
So keep the record straight.
Yes.
So that quashing will be easy. Tomorrow she may not go and challenge it, saying that behind my back it has been done.
Obliged.
Even state was also not a part.
Obliged.
Then the entire exercise is put out. You keep everything ready and quash it. What is it?
I am permitted to add state as open.
Yes, I have already.
Yes.
Petitioner granted permission to implead the state. Mr. Rahul, although Mr. Rahul accept notice for the stay and advance copy is supplied to him. Yes. And the record is straight. The record you have to keep everything. Unnecessary problem.
29.
Yes,
In
sir.
this case, I am for the opposite party number 2, my lord, informant. Your lordship kindly remember that in the last occasion, the owner had filed an affidavit stating therein that there has been a settlement between two brothers. Accused elder brother lost an affair against the younger brother, which was registered for commission of offense under section 420 and 120B. And during the pendency of that criminal proceeding, a civil suit was pending in the Learned Court below. And so far as that civil suit is concerned, amicable settlement has been made between the parties. That suit and so far as the informant is concerned, he has also sworn in an affidavit in the Learned Court below that he will withdraw all the cases. He will not proceed with the cases filed by him. My learned friend, senior advocate Prafulla Ratha was appearing, and he is absent, my lord. Let it come some other day.
If you have settled everything, you have given an affidavit.
Yes, my lord.
It is a fight between two brothers.
Two
remains?
Two brothers, but in the meantime, I have already taken instruction from my client that my younger brother is talking outside that after quashment of this proceeding, order of cognizance and entire criminal proceeding, he will file a suit for damage and a malicious proceeding against me. And that observation may be given.
How can I, if he has
No, he cannot. He cannot.
I can't give the
No, he cannot.
If I quash the proceeding,
No, he cannot.
where is the question of, where is the principle of malicious prosecution? If he suffers the prosecution, then malicious prosecution. If I quash, where is the malicious prosecution?
His version.
He may say whatever.
My lord.
Is a suit for malicious prosecution is maintainable?
No, not at all maintainable.
If I quash it?
No, not at all.
What kind of observation you are seeking? Malicious prosecution is only attracted when he suffers the prosecution and get acquitted. I am quashing it. So then, at least it Friday is not there. Mr. Ratha is not there. No? You have settled your brothers and all. The younger brother may say whatever. So, shall I
Friday, my lord.
Shall I keep it or I'll reserve and quash it?
More kichhi objection nahi. I don't have any objection.
Okay.
I don't have any dispute, my lord.
Non-APS for the petitioner.
As my friend is not present. My lord, your lordship.
He'll give you.
My lord, it is a case out of the left the world affairs Sanyasini. But my lord, पढ़िली clearly. Annexure 1 13/5/13 रे विवाह हला से दिन ठू तांकर निजे Annexure 1 पेज 13 ले CP फाइल कले फॉर डाइवोर्स पेज 14 माइलर दी पिटिशनर स्पेंट जस्ट मासे परे से आगुरु तांकर सन्यासिनी हेई गलेनी दी
सन्यासी हेगिरी बाहा गले हेले
बाहा निजे बाहा हेले सन्यासिनी कि पिता मातांको जोर प्रेशर बाहिथिबे माने पेज 14 Petitioner spent most of the time for worshipping Lord Krishna. The respondent and his family members allow the petitioner to violate times of worshipping. Respondent and his family members suggesting the petitioner to do housework with worshipping, but the petitioner could not adjust herself.
That is 13 petition.
13 petition.
It is allowed.
एटा पेंडिंग थिला भितरे से पुणी उटे डीवी फाइल कर देले बाघर हला 13/5/13 रे डीवी देखिले हिंसार तारीख 13/5/13 बाघर केतळ हला हिंसा केतळ हला बाघर हला 13/5/13 हिंसार तारीख समय 13/5/13 पेज 19
annexure 3
तेणु माइलर एथिरे आउ सीपी
19 इज डीवी केस मेले
हां माइलर एबे ए जो माइलर उटे वेरी इंपोर्टेंट क्लॉज family court रे my lord.
Where is she?
My lord, she तार से सन्यासी नहीं कच्छी मतलब एबे 13 VI रे clause of my lord ground of divorce
Notice has been issued.
My lord,
Notice has been
notice issue has renounced the world by entering any
What do you
religious
what do you
order.
want?
आमे से
You
marriage
you
consummated
you
marriage
become a
consummate है
sannyasi.
marriage consummate है नहीं marriage consummate है नहीं my lord presently what a DV case is pending in the family judge.
1 minute, 1 minute. What she saying?
My lord. Well, presently
1 minute, 1 minute.
my coach my lord.
The sannyasi married or not, conjugal relation is mentioned not, that will be decided
No, you decide whether you will remain a sannyasi or you will litigate. No sannyasi should have a litigation. That's the first thing. And you want to be sannyasi and you want to prosecute your entire in-laws family. What is this? You say in the petition, 13 petition filed by you, say that I am a sannyasi, this, that. And at the same time you file DB. What is this?
And the allegation in the DV is different, my lord.
All these are cooked up stories. How much you want? Money you want?
Nothing, my lord.
Then want them to go to jail.
Yes, because they have tortured me, my lord.
And they will be remaining in jail, you will be a sannyasi.
I am not a sannyasi.
It is the philosophy.
Whether I am a sannyasi or I filed that divorce petition, that will be decided that 13 section 13 case matter. But this is that is nothing to do with the DB case matter. Because
what is the stage of that divorce petition filed by
my
her?
lord divorce my lord 1 week
You are not appearing there.
My lord how say 1 week back thila divorce ଏବେ ଯୋଉ ଗୋଟେ my lord benevolent ground section 13 VI if the spouse one of the spouse has renounced
she doesn't say I have renounced.
challenge
Does she say renounce? Where is that?
my lord renounce the world by entering any religious order. So eight more ground.
See, you don't understand. See the pleading of 13. She doesn't say that I have renounced the world. She says that I am worshipping Krishna. Worshipping Krishna, dedicating the entire time for worshipping is not renouncement.
Well,
you may say whatever. Where is the renouncement? What?
My lord, yes. The petitioner is not at all in a mood to lead, say, page 14, paragraph 9.
That is renouncement.
No, my lord. Paragraph 9, sorry, page 14, paragraph 9. The petitioner is not at all in a mood to lead a conjugal life with the respondent, and for that, as a devotee of Lord Krishna, is not physically able to lead a happy matrimonial life.
Very renouncement. So me religious renouncement.
My lord, say regarding the
do you know religious renouncement follows with some customary functions, so many things. Declaration is recognized. Unless you show that she has renounced the world, you can't say she is a sannyasi. Sannyasi, she is devoted, she is not happy in the materialistic life. She is devoting time for worshipping and all. This is it. And so therefore she is not interested to continue the marital life. That's one thing. But she has not denounced
that part.
For the purpose of religious.
At the time of preparation of the prosecution, marriage taken place on 13/5/13.
No, that is on merit.
Hinsar tarikh hauchi 13/5/13.
Same day.
Same day. Annexure 3, page 19.
No, that is on merit 19.
Yes, madam. So that is why, for the benefit of both the parties, family court.
Why don't you go
family court?
Why don't you go for settlement?
I mean, settlement hai because
there is no settlement. As long as my father was there, they were pursuing for settlement. Now I am helpless, madam. I have a blind mother, madam. That happened, madam, kind of last to the prayer person in this case, madam. But they are challenging.
I do not want to linger the litigation because I have a good career.
Do you have any demand?
Good career, both the party asundu. both the party, both the husband and wife may appear before lordship. Because today 35 years age I will face the litigation.
I understand, see, but
he
is getting adamant now because you yourself have filed a divorce petition.
with much fairness, they stand before lordship and
I think you should go to mediation. Try.
Mediation say adamant say I will not go because I have
So
accepted.
then I have to decide the DB case on the basis of merits.
But DB case I will supplement certain evidence. Yes.
DB case I have to pass on merits.
Yes.
As per merit, my lord.
You address that.
I'll convince.
You address that. But see, according to me, these are the frivolous litigations. Unnecessary ego of the two persons. And if you are not interested in the marital life, you leave it here and take some permanent alimony or something. You tell me the figure, I'll tell them. Your mother is not well, at least you can spend that money. Lead your life. What is this? I can't have good marital life with you, but I'll see that you are in jail. What is this attitude? You bring them.
Sango kind of
you have decided your course. You decided your course that you have filed 13. Why have you filed 13 then? No. But why have you want divorce? You have filed the petition. You withdraw it. Withdraw 13. If it is so forcible, withdraw it. You can't have both. This is only egoist. You don't want divorce, but I have filed a divorce. What is this? That was done force matters. There is someone else is playing.
Yes, my lord.
There is someone else.
I'm
simply adjourning it.
My lord, ମୁଁ conciliation କହିଲି 13/5/13 ରେ ବିବାହର ହେଲା 13/5/13 ରେ ହିଂସା ତାରିଖ before this protection officer କୁହା ହେଲା ବିବାହର କେତେବେଳେ ହେଲା ହିଂସା କେତେବେଳେ
ହେଲା don't I will not go into the technicality. If I will understand that there is ego issue, I'll watch it.
Yes, my lord.
Then let us put an end to it. Otherwise, both of them are going to spoil their life fighting out this case unnecessary. Adjourn, simply go to week for child play and you decide. I will not be a party to those things. You bring them, I'm ready. You bring them. You bring your client. You bring your client. You bring them. We'll persuade them.
Yes. With all fairness.
Yes. You bring them. See, if these things are quashed, at least they will be peacefully living their life.
Yes, ma'am.
She will be living her life and he will be living her. This ego will kill both of them. And take want some money from them. Yes.
101. Entering motor to continue.
Oh, same. No.
Ma'am, obliged.
Yes.
101.
Challenges the framing of charges. Is 420 294 506.
Entry motor is there.
Notice of 12/1/2024. Directed to file a subsequently it was adjourned from time to time.
Pursuant to the order dated 12/1/2024, the petitioners have not filed the joint affidavit. Rather, they have been seeking time to comply the order dated 12/1/2024. Today, when the matter is called up, nobody appears for the parties. It appears the parties are not interested to prosecute this matter. Accordingly, the matter is dismissed. They are not interested.
102.
May I please, your lordship. Last time, your lordship issued notice. This is arising out of a 125 proceeding on lordship in a peculiar circumstance. Maintenance were awarded and some arrear were dues. And
you have opposite party too.
Yes, yes, I'm for the wife and
in the first execution case, your lordship, I specifically submitted it for the loan.
What is the marital status now? Continuing it.
my lord, it is not continued. For first 3 lakhs, that is the first execution proceeding. He was arrested and go behind the bar and incarcerated for 1 month. That they have taken a plea that the it has been satisfaction. But the Supreme Court says no. That is a mode of enforcement, not a mode of satisfaction of the area amount. That's altogether different. Now the present second execution case was filed. That the present writ application read before lordship to quash that execution proceeding where only 25,000 was area maintenance. Even though lordship was after directed to current maintenance since March, my lord, he has given only one month maintenance. All this the conduct and my husband.
I have never.
And I am also with my daughter prosecuting 3rd year and a son prosecuting in school, my lord.
That is already matter of record.
You are working as what?
Yes.
You are working as?
Lord, I am doing nothing.
That because
as per my instruction, your lordship, he is doing. He is just a daily laborer, your lordship.
Daily labor?
Yes.
Lord, that has been
Your
answered.
For a moment, let me say. My lord, the marriage was held in February 2008. And after 8 months, in the October 2008, she filed an FIR. That is under Annexure 1. On the allegation of cruelty, torture, dowry harassment, and everything. So FIR was lodged. FIR was registered under 506, 498A.
I'll just call it.
ନେଇଯିବେ ସାଙ୍ଗରେ 102 କାର ତାକୁ ନେଇଯିବେ ସାଙ୍ଗରେ 102 ଟା 101